And my lord, the contract agreement I have annexed the relevant portion, my lord, of the contract agreement, my lord. Page 37 is the arbitration clause, my lord.
Yes.
Conditions number 70, my lord. There is an arbitration clause, my lord.
Right, heard, learned counsel for party. This is the application under section 11 of the Arbitration Reconciliation Act 1996, taking a direction for appointment of a court. Issue notice written about 4 steps on. You're appearing for
Yes.
MSP Sharma appears for all respondents.
All.
For all respondents. Therefore, notices are waived. However, extra copies be furnished within a course of 1 week from today. It's after the return.
Obliged.
Obliged, my lord.
Who's for the respondent, Mr. Bora?
Criminal husbandry and veterinary department, pending confirmation M. Kotu.
Did you see the last order?
Yes, that matter. He did not supply me anything.
Huh?
I asked for a copy of the contempt
You did
petition.
not submit him copies.
Copy, sir, submit, my lord. Nothing. Dibora.
When?
I have not received anything.
Service copy. When did you serve?
It is before, my lord. It is. I have not received it, your lordship.
Is that your
Dibora.
signature or not your
No, not my signature. Not my signature. Somebody from government office, they have received it, but no, not taken. I have not received it. Even.
Do you have an email?
Huh?
Email.
Email. Email. Apuna email. Yes.
You send him a soft copy today.
Public.
Mr. A. Das, counsel, appears for the petitioner. Mr. D. Bora. Do you have an extra copy with you? Extra copy of the
I will
petition?
give you. Only in this.
Do you have a copy now?
Sending it, yeah. Contempt. No, my lord, I will give.
Mr. D. Bora, appears for the respondent. Mr. Bora submits that pursuant to the last order dated 28/3/2025, extra copies were not served on him. So, Mr. A. Das, however, submits that the copies were duly served on the government office, which however, Mr. Boras claims that he has not received. So, under such circumstances, we permit Mr. A. Das to serve one set of extra copy or to the writ petition to the government council to complete his instruction. In addition thereto, he may also furnish soft copy by way of email. Let this copy be served. You serve him today.
Yeah, on this day.
Let the copy be served during the course of the day. Mr. Bora will obtain his instructions after 2 weeks. This matter on 19th May.
May I please your lordship? Okay, we have received the copy of addition verified by the respondent of the lordship. As much as additional affidavit, the respondent number 2 has returned from the office on 2/4/2019 lordship. During this period, due to insufficient fund, resolution number 2 couldn't pay the arrears to the petitioner's lordship.
Hmm.
And after her retirement, she has no knowledge about it. And she has submitted that the present incumbent of the board may have the knowledge.
What is there in the additional affidavit?
Lordship 28/3/2025, Lordship. Paragraph 5 and 6, Lordship. Content on more to be stated, Lordship.
You are still the chairman.
No, Lordship. Already I have retired, Lordship, 2/4/2019, Lordship. After submission of the order 2012/2019, Lordship, then after 3 months, I have retired, Lord. I was retired, Lord.
You implement the new chairman and the executive officer.
Lordship.
Counsel for the petitioner is permitted
Uh,
2 weeks' time.
Kindly fix a date because it's a very long pending matter.
You complete the proceedings.
I'll complete that.
Once a person retires, you should have got the new person in.
Lordship. I'll complete.
The present chairman and the executive officer of the Dhemaji Municipal Corporation, Dhemaji Town Committee. She therefore prays for 3 weeks' time to complete, to take necessary steps for completion of the said respondents. List again after 3 weeks.
Highly appreciated.
Well, dear. Your Lordship, this is a covered matter, Your Lordship. On the last occasion, I have already submitted an order of this honorable court. And the petitioner was not present, therefore I requested the court.
Where is the order?
Your Lordship, that's on record, Your Lordship. I have submitted on the last occasion.
Review petition.
No, the case number 2940 of 2021. I have submitted a copy of Your Lordship. In fact, the petitioners are also same. The private respondents are also same, Your Lordship.
But if maybe between the similar cases, there is a judge
I have given.
covered,
Covered.
Yes,
covered lot.
their prayers are negated by this honorable court, Your Lordship.
The counsel for the parties submit before the court that particular issue has been answered by coordinate bench against the writ petitioner
2940.
claiming similar relief.
2940 of 2021 and 6006 of 2021.
WPC 2940 of 2021 and WPC 69
6006 of 2021.
6006 of 2021. So both these writ petitions were taken up together and by judgment and order dated 21/3.
Yes, Your Lordship.
2025. The writ petitions were disposed of. It is not dismissed.
Your Lordship, the
Not
prayers
rejected.
were negated, and what happened, I want to say that the prayers were negated, but the direction was given that, but the direction was given, which is your Lordship, we find at para 29.
Where are the prayers negated?
Page 28, para 28, your Lordship. In the case of PS Satasiva Swami, it has been laid down that a challenge to promotion should be made within an outer limit of 12 months, as any belated challenge would amount to unsettling the settled position. In any case, the writ court is a court of equity, a bona fide, and diligence of the party approaching the court are relevant. Consider the court is also of the view that further promotion to the rank of assistant matron have been effected in the years 2021-22, giving benefits to the rival parties. The said aspect of the challenge belated made is not required to be gone into, your Lordship.
Who's for the department? What do you say?
My lord, it is covered, my lord. Already that issue has been decided, my lord.
That is what you are submitting
Yes, my lord.
in terms of the said order. The writ petition stands closed. Directing the authorities to prepare the gradation list in the rank of assistant matron, strictly in accordance with law. And if the department takes a decision for further promotion, then the same shall be done strictly in accordance with law, and particularly by following the prescription of the rules of 1991. Writ petition accordingly disposed of. No order.
Your Lordship, I am appearing for the private respondents.
Mr. R. Pina for the private respondent, Mr. Bora for the PT Bora for the DP Bora for the respondent. There's some caveat filed by you.
No, it was long back. In fact, the caveat could have been discharged.
Caveat 9890, therefore discharge.
Deeply obliged.
Deeply.
Yes.
Person has retired on 31/8/2006 from GMC. And on 1/11/2022, there is an order from this court to pay the pension. Still, we are now from 22 now we are in 25. Only a part of the amount has been paid and the other they are still delaying it. You are saying?
One. Well, affidavit already in file, my lord. A part of the amount has been released by the government. That has been already been distributed. We are seeing the remaining portion of the fund, my lord. The moment the government releases, we will release it, my lord. These are all area salary of the retired persons, my lord.
Which
There
is
are
the order you are-
583 persons are there.
Which is the order you are seeking compliance of?
But page 9. The operative portion is at 170. 117.
Yes. How much time do you require?
My lord, what happened, my lord? We have written to the government to release the particular fund that are around 27 crores. 12 point some crores have been released. Immediately we have distributed to all the persons. There are altogether 583%. The moment the government releases that particular fund, my lord, we are ready. That's why thereafter the
Government means which? Finance department?
finance department,
Yes, finance.
government means
Lordship, we have written to the department also, Lordship, but a proposal if, because the financial year has started, Lordship, so the amount will be available to them. If there's some shortfall and they have reached, I have asked my learned friend to produce a copy if they have communicated to the government.
That because in 2023 it was communicated, then the 12.5 crore rupees had received, my lord. Remaining part has not
No,
been
now
received.
do you want money or not?
Now, we want money, my
You
lord.
want money. So give
Subsequently,
him
some development is there, my lord. I will give
why don't you give him that proposal?
Well,
Whatever you sent.
my telephone instruction is that proposal had been sent, my lord.
Ah.
I will get the executive the
You give him that copy.
copy to him, my lord.
You give him that copy, he will
Lord, sir.
find it out.
Lord, sir.
What is it? Mr. B.D. Kaur, Senior Counsel, appearing for the petitioner.
On 6, Mala, government of Assam is taking a 900 crore loan. Probably they are waiting for it or what.
Hmm?
On
I
6,
have no
government has today in the newspaper, it is making headline that government has now appeared for 900 crore loan by giving the government bonus security for 30 years.
Whatever. Mr. S. Bora, Counsel for the GMC submits
My lord, for the respondent number 1, my lord.
for respondent number 1. Submits that because of financial crunch, the amount required to be paid to the petitioner could not be, petitioners could not be released. What is the total amount? You have,
Total amount will be around 27 crores.
the requirement of fund is to the extent of rupees 27 crores,
And 12.5
and
crores have
out
been
of which 12.5 crores
already been
have
released.
already been received, and the same has
And
been
the same has been
disbursed
released.
to the petitioners. The balance amount is awaited from the department concerned, and for which proposals have already been sent. So, since the counsel for the finance, Mr. H. Aliha, is also present,
That's the respondent number 2.
for respondent 2, the respondents are expected to apprise the court by the next day as to when the amount directed to be paid to the petitioners can be released. When the directions contained in the order dated so and so will be complied with. The counsel for the respondent 1 is at liberty to share the proposal papers with the counsel for respondent number 2, if so advised. List again after 4 weeks. We'll have it after 4 weeks.
29, Mala, of May or 30th of May, as per your lordship's comment.
30th of May.
Yes.
Lordship, the petitioner has not provided us with the GIS certificates, Lordship. So due to want of the certificate, we are having a problem in paying him the GIS, Lordship. But before another 4 weeks time, Lordship, the process is going on. We are collecting the data from all the districts, Lordship. Pension, arrear salary, everything has been paid, Lordship.
Petition in a bad written condition, my
Now,
lord.
what is he supposed to supply?
GIS, only GIS is remaining, Lordship. Group insurance.
No, you said he's to supply.
Yes, the GIS certificate, Lordship. He was posted in different places
You
of posting,
give the
Lordship.
certificate.
He is in a bad written condition, my lord. I will inform his son, my lord.
Now you inform and give it to the petitioner, respondent.
But I will inform his son to communicate with the respondent.
Counsel for the respondent, Ms. Arbora, prays for further 4 weeks' time to apprise the court regard to the status of release of GIS to the petitioner, GIS dues to the petitioner. The amount available to the petitioner under GIS. She, however, submits that the GIS certificate, if furnished to the department, will expedite the matter. Stop counsel for the petitioner submits that he will try to obtain the instructions and furnish it to the council by the next date fixed. List after 4 weeks. 4 weeks.
A date may be given after 4 weeks.
When will you supply the certificate?
I will supply, my lord, within 1 week. I will.
Within 1 week. Let it come after 3 weeks. 26th May.
Okay.
Wait, please.
Yes.
As per Lavazima order dated 24/11/2024, service is completed. I am from private respondent number 5, Lordship. I see 2 weeks, you have 3 weeks time to file the affidavit of opposition.
As per office note dated 29/11/2024, service report is complete. Mr.
A Kakuti.
A.
For
Kakuti
R5.
appears for respondent number 5. Mr. S. Dotto for
For respondent number 2, your Lordship.
respondent 2.
2.
Mr. Deka
Access for 1, Lord.
appears on behalf of Mr. Respondent number 1. So who is for 4? None represents the respondent number 4.
Go to Kedar.
Although
And-
this have been, although notices are shown to be complete as per the office note dated 20/05/2024. At least after 2 weeks.
Please, your Lordship. This contempt petition has been filed, the violation of the order dated, my lord, 1/2/2024. Case, my lord, 15. My lord, present status of the, my lord, as per the last order, my lord, just submitted to the SSC to declare the result. My lord, till now, my lord, we have not instruction regarding that, my lord. Actually, SSC is respondent number 1. So respondent number 1 is not yet represented, my lord. We are for CRPF. We have done our part, my lord. Now, burden is upon the
Who
SSC.
represents SSC?
SSC, my lord, till now, respondent number 1, 4, and 6 is not represented, my lord. Last order, my lord.
But you can represent it.
No, let's contempt, my lord.
Contempt.
Contempt. I am appearing for respondent number 2 and 5, my lord, CRPF and CISF, and 3 is for respondent number 3. Regarding 1, 4, and 6, still, my lord, 1 is SSC, my lord, 4, my lord, 4 is SSB. What happened, my lord?
You are a CGC.
My lord,
We permit you to obtain instruction in your capacity. as-
my lord, my lord, my lord.
Respondents number 2 and 5 and 3. 2, 3, and 5
Yes,
are represented. Service on respondent number 1, 4, and 6. Is it complete? No.
one others complete, my lord, 6 hasn't appeared. my
1,
lord.
4, 6, not complete.
Not complete.
Service report on respondent 1, 4, and 6 is still awaited. Will you take fresh steps?
Man, it takes one, my lord. For respondent number 1, my lord. 4 and 6 may not be required, my
Since
lord.
this is a contempt matter and the service on respondents 1, 4, and 6 are awaited, the court requests Mr. Parakor, in his capacity as CTC, to obtain instructions from respondent number 1, 4, and 6.
Only one, my lord. 4 and 6 are not relevant.
We are giving it.
My lord,
4
my
and
lord.
6. Let the matter be listed again after 4 weeks. MSL may be for respondent.
Date may be fixed, my lord.
30,
Obliged.
30 May.
Obliged. Thank you. In this matter, my lord. My lord, item respondent 2, I am appearing, my lord. My lord, Ukalat, my lord, today is going to file, my lord. So some time will give.
Mr. Kadir appeared for the petitioner.
My lord, regarding 1 and 3, my lord,
1 and 3 ID card is awaited.
wait, but my lord, I have filed an additional affidavit, my lord, finally, my lord, additional affidavit, my lord, I have an extra track record, my lord, of my taking steps, my lord, where it is mentioned that the item is only delivered in the month of
You
August, my
point,
lord.
all right. 1 and 3 stands awaited as per the office note dated 28/4/2025. Mr. Kadir, however, submits that he has filed an
Additional affidavit
affidavit. Additional affidavit is not here.
on 6/12/24.
It is not here. Filed an additional affidavit states that he has filed an additional affidavit which shows that as per the track record, the package has been delivered.
Yeah.
Stop. Let the registry place the matter before the Lozima court
Lovely.
for necessary endorsement / order. Mr. S.K. Mehdi appears for
Respondent 2, my lord.
respondent 2 and is permitted to file his
For-
objections or
for
exceptions. Let the matter be listed after 4 weeks.
File your-
Hello, this judgment of this court is updated 24/11/2023, page 15, madam. That
One 1/5.
1/5, my lord. For regularization of the petitioner.
Hmm.
And this order is updated 24/11/23, madam. Not complied till now, my lord.
Yes.
No excuse, Lordship. I'm not making any excuse. So the issue is we had filed a writ appeal. Now the writ appeal was also dismissed.
Hmm.
The instructions that I have received from the company is they are preparing an SLP, but however, parallelly, they are also processing the file for regularization. This is my instruction. If Lordship will give me 2 weeks time,
All right.
I may either place the SLP's result or the affidavit that complies with. That's my instruction.
Mr. B. Barua for the petitioner, Mr. A. Sharma for the respondents. Mr. Sharma submits that the intra-court appeal filed against the judgment and order dated 24/11/2023 in WPC 3651 of 2019 stood dismissed. And steps are being taken to file an SLP by the IOCL. So meanwhile, parallelly, the steps are also taken by the IOC for compliance of the order directions contained in the order dated. Let the matter be listed after 2 weeks, enabling Mr. Sharma to apprise the court as to compliance of the order, end of leave or any such order that may be passed by the High Court.
The Supreme Court.
After 2 weeks,
Yes, Your Lordship.
26.
Obliged, Lordship. Obliged.
May I be Lordship? Lordship, the notice for respondent number 5 is not served, my lord, due to the change of his address, my lord.
Hmm.
So today I am praying for
Mr. Kumar submits that fresh steps will be taken on respondent 5 at the corrected rate.
yes, my lord, for correct, with correct.
The corrected rate, the praise for 2 weeks time. MS,
I'm appearing for respondent number 1 to 4 on behalf of RDB. K
Your-
Deka.
your name,
K Deka on behalf
A
of
Deka,
RDB.
appears on behalf of RDB for respondents
1 to 4. Lordship.
1, 2, 4. 1, 2, 3, 4. List after 3 weeks.
Deeper. Anathan appear for respondent number 1.
No, I am appearing on behalf of respondent number 1. But the direction against the COPDO,
Page 69, my lord. To regularize the service of the petitioner. Page 69, my lord.
paragraph 29.
Paragraph 29, page 69, my lord.
Yes.
Within 3 months from the receipt of the copy of this order, my lord. Thereafter, my lord, page 70, my lord, I submitted representation before the, my lord, respondent number 1. Page 70, my lord. On 23/9. But till that, my lord, no regulation was done by the respondent, my lord.
Lordship, the direction was given to the respondent number 4 in the original writ petition, Lordship. It is
This is the writ petition 69.
My lord.
69, Lordship. The chief controller Village Defense Organization Assam, Lordship.
No,
COBLO.
it says respondent authorities.
Yes, Lordship. No, Lordship. Specific, it is 29, Lordship.
Yes, paragraph 29.
Yes, 29, Lordship. 29 specific direction was given, Lordship.
Specific to the
Consider, consequently, the respondent authority are directed to reinstate the petitioner as
Your circle organization, it is
Yeah.
defense organization.
yes, Lordship. Now, Lordship, the copy of the contempt petition is not received by me, Lordship. Only
Second step.
only this one, Lordship.
You serve a copy, you
Yes,
get your
Lordship.
instructions
Yes,
and
Lordship.
comply
Yes,
this
Lordship.
order. What
I
are
will,
you
Lordship.
saying?
I will, Lordship.
Mr. K.R. Patgiri, learned counsel for the petitioner, appears for the petitioner. Mr. J.K. Goswami appears for the all respondents.
No, Lordship. Only respondent one, Lordship.
Respondent one.
Regarding others, Lordship.
The respondent one,
Yes, Lordship.
he who submits that he has not received a copy of the contempt petition. Let a copy of this contempt petition be served. Extra copy be furnished to Mr. Goswami to enable him to obtain the instructions in the matter. List again on 28th May.
Oblige.
Yes, please, authority.
Yes.
Lordship, in this case, respondent number 6 from Nepal, Lordship, we have earlier taken step, Lordship, but
They want to take steps through your department.
मला she is a pension holder. Now, when she is getting only pension, direct link with the department is there. Only she has link with the bank only. It is difficult. So,
She is the first wife
Lordship,
and you are the second wife.
second.
but steps may be taken to register post. It will be better. Directly, department, if there is the employee, another thing. Now, pension holder, only she has relation with the bank only. She's
On
taking
what ground are you claiming pension?
Lordship, second wife and under the 6 years rules, Lordship, she is entitled. And
Where are the root 3 years? Rule number?
Lordship, it is
Pension rule.
Lordship,
Pension rule.
rule 48, Lord.
Forty-eight. Where? Which route? Which part?
pension.
There is a clarification that second wife will not be entitled to pension.
In
But,
terms of
but,
rule 54,
Lordship, children entitled, Lordship. There are 2 children.
Where?
Lordship, Lordship, I certify your lordship. Any other take maybe elastic.
Regarding that, matlab, we have filed only affidavit, matlab, as per 54 is not in the realm. Matlab, now regarding service only, matlab, but department is difficult,
After 2
matlab.
weeks, enabling the counsel for the petitioner to apprise the court the relevant rules under which the second wife is entitled for pension as prayed for. Mr. K.K. Parakar appears for the
1 to 5.
one respondent 1 to 5.
Right. Lordship, conducting the chill PP whatever is in another court. Lordship, matter may be fixed at 2 p.m. kindly.
All right, 2 p.m.
Oblige.
Suitable matter.
But PK maybe PC appeared in this case, matlab, today some difficulty on his part, matlab.
Who?
PK maybe, matlab. 2 weeks time required, matlab.
What is your claim?
My lord, claim is retrospective promotion of the petitioner, my lord. My lord, he at the time of his initial posting, my lord, due to the clearance of the SB report, his appointment was delayed, my lord. As a result of which, my lord, his juniors juniors in the merit list were appointed before him, and subsequently they have been promoted before him, my lord. And in a similar matter, this honorable court has been pleased to pass a judgment that, my lord, the retrospective promotion may be given to the petitioner in that case. And this petitioner is also covered by that case. But since today PKMD is not prepared, my
He is handling the case, matlab.
as of today, the petitioner is serving as commandant. His junior has been promoted to the post of DIG, my lord.
Yes.
2 weeks time, matlab.
Mr. D.P. Bora for the petitioner. Mr. Parakar submits that the engaged counsel, Mr. P.K. Medi, CGC, is not available in court. Please, for a week's time. Matter be listed after 1 week.
Obliged, my lord.
Lordship, here I am appearing on behalf of the board lordship. Lordship, though we have prepared the affidavit lordship, but recently in February 2025 lordship, a bill has been introduced for provincialization of our employees of the municipal bodies lordship. So this bill is their lordship. So till date, we have not received any communication from the respective department lordship regarding any staffing pattern or promotion or anything like this lordship.
That is a bill,
Yes, lordship.
not an act or a rule, is it?
Yes, lordship, that's true.
Then
And as per my instruction, lordship, this is the recent instruction that the resolution that they are, that means assailing here, lordship, on the basis of which they are claiming that he is so promoted to be so and so, this resolution has not been given any effect, lordship. The petitioner is till date, lordship, he is working as junior engineer, lordship. And
where is the resolution?
This is an order, lordship, at page 26, lordship. The resolution is at page 23. Resolution number 8 at the bottom, last graph, at the page, page 23. Resolution number 8. Junior engineer Sri Minal Kanti Das joined in service on.
You want a direction to give effect to this.
Lordship, he's work in terms of this resolution, he is working as an assistant engineer. And the salary he is receiving is junior engineer.
Where is there any separate order permitting you to work as assistant engineer? Sorry.
Yes, at page 27, Lord.
27.
At page 26, Lordship.
He's upgraded. Why do you
Yes.
say it has not been
And,
given?
no, subsequently, Lordship, there is a communication by the Deputy Commissioner because at that time, the chairman who was holding the post of chairman, Lordship, he did not have the financial power, Lordship. All the financial power was with the Deputy Commissioner of that particular district, Lordship. So there was some Lordship communication, but ultimately the Deputy Commissioner who was holding the financial power, Lordship,
How
he,
can the financial power of the
yes,
board be
Lordship,
held
at
with
that time,
deputy
yes,
commissioners?
Lordship, this was there
How?
at that particular time.
This
May I
is
say one thing?
contrary to the act. It's contrary to the statute itself.
Yes, Lordship, but to that effect also there are resolutions, Lordship, there are communications, because the financial power was curtailed at that time, Lordship.
Maybe, Lordship, but in order to downgrade me, Lordship, there has to be some show cause notice, Lordship. Otherwise, they cannot do it directly, Lord.
You get your affidavit on record. You have been
Lordship.
given 2 weeks time earlier.
Yes, Lordship, but because of this, Lordship, we.
What has a bill got to do with it? It's a bill. Either you
Yes.
file it or we pass orders, whatever
Okay,
is
Lordship.
available here. It's a case where the board has taken a resolution, given effect to it. He's not been given the
Lordship,
salary.
explain this one, Lordship.
Mr. M.P. Sharma for the petition, Ms. M. Bhattacharya for the respondent state, who prays for further 10 days time
10 days, Lordship.
to file the affidavit. Prayer allowed, list again on 26th of May.
Lordship.
I'm obliged, Lord.
Deeply obliged.
In the earlier occasion, Lordship has directed me to obtain the instructions. So I have received the instruction. As per instructions, he has received the GIS money and pension with one increment due on 1/7/16. Lordship, may kindly peruse this.
So GIS has been received.
Yes, Lordship.
Only prayer, my Lord, that page 29 of my writ petition.
Only left the unutilized leave salary.
Page 29. A letter from AG to the respondent department.
So what they say here is something else. They have not received your service book.
For that, Lordship, the director has already written a letter to the inform the secretary. Lordship. That letter is before you.
So who's responsible for the pay fixing?
Government, Lordship.
Okay. You are representing the government also.
Yes, Lordship.
Who?
I have submitted one letter, Lordship, dated 25/4/25 regarding this, Lordship. The joint director has not received the earlier one.
Hmm?
So the annexure 29 Lordship, page 29 Lordship,
Hmm.
that this day, Lordship, first instruction that he has not received that letter,
Joint director.
joint director. So now,
So it
the
is a part
direct-
of the petition now.
yes, Lordship.
So you are now taking steps.
Yes, Lordship.
But what steps have been taken by the government?
Comment, this letter is only on 25/4/25, Lordship. So we'll have to take in instructions again, Lordship, in this regard, Lordship.
And MS Bora or D Bora for the health department. MS Bora submit places to communication before the court. Communication dated 24 April 2025 by Joint Director. The director reflects that the final payment of the GIS savings account in respect of the petitioner has already been drawn and dispersed. However, for finalization of the leave salary, unutilized leave salary,
Yes.
the service book of the person of the petitioner has not been returned to the concerned office, has not been received back. Consequently, further communication dated 25/4/2025. The joint director, the director health service has communicated with the secretary of the health department with regard to cessation of his pay with effect from 1/7/2016 to the date of retirement for release of unutilized leave salary. So, let the matter be that after 4 Accountant General, do you have anything to submit?
As per our if it got in allowed the increment.
The Torah pay demonstrate right whether instructive represent the accountant general. It's tough to prove.
Please, your lordship. Lordship, in this matter, my lord, the respondents were directed to file an affidavit, my lord.
Well, Lordship, I pray for further 2 weeks' time, Lordship, to get the instruction not received, Lordship.
My prayer is date may be clear.
On behalf of SSR, Lordship. All the respondents, Lordship.
Your Mr.
Yes, Upadhyay.
S.
Upadhyay.
S. Upadhyay appeared for the petitioner, Mr. A. Deka, representing Mr. H. To be different. And further 2 weeks time be granted to complete it. It's again after a week. It's on 28th.
Deeply obliged.
Sublime. Please, Lordship. In this case, Lordship, petitioner was compulsory released from the service in the year 2018, Lordship. This letter was challenged before this honorable court, Lordship. This honorable court by order dated case number 32, Lordship. Direction was given to the respondent authority to conduct an inquiry regarding his
Date of birth, Lordship.
Lordship, in this case, I need 2 weeks time. Lordship, you may fix a date after 2 weeks, Lordship. I will have the instruction.
Further 2 weeks time is paid for by the Standing Council. Irrigation,
Lordship. The date fix karayega.
6. Liberty to complete the construction. The APT home. Again, after we give you 3 weeks on 26th of
Date and everything.
26 May.
Lordship, already,
Obliged.
already.
May please, Lord. Okay, in this case, no affidavit has been filed.
Yes, MS Bhattacharya. Yes, DAD, what is happening?
Lordship, in this matter, we have already this thing with him, my lord. 2 weeks time, my lord, we'll file an affidavit, my lord. Because there are connected 3 matters, my lord. We has to be filed together, my lord. Today this matter has come, my lord. Same bungalow peon, my lord. 3 matters connected are there, my lord. So sometime maybe given.
The other matters you have filed your affidavit.
The other matters, no, my lord. Together we'll be filing, my lord. In all the 3 matters. Today this has come, I don't know how, my lord.
You don't know how. It has been come because the registry has listed
No,
it.
that is there, my lord. That also, I think, with the other 2 matters, I think it's supposed to
There
be
is no
connected.
order here. That
This
it should be listed along with the other 2 matters.
When this matter was fixed, my lord, but the other matters also, my lord, it will be taken up together later.
You
I
file
think.
it within 1 week.
Fine, my lord.
1
I'll,
week.
I'll do it.
It is submitted that there are similar issues are pending in other 2 petitions. The council for the GAD therefore raised for further time to file his affidavit in the matter. It is seen that by earlier order, sufficient time was granted to the respondents to file the affidavit. At the request made, this court grants further 10 days time to file the affidavit in the writ petition with the matter being listed again on 21st May.
Deeply, my lord.
My lord, this is a covered case, my lord.
Covered by
Sorry.
2006 order. Judgment.
No, it cannot be covered, my lord.
No, I'm talking about the judgment passed by the coordinate bench.
Exactly, my lord. This is a matter of 223. The OM came in 24, my lord. And what did the order say, my lord? How can it be covered, my lord? He has to first challenge the OM. He did not challenge. So, my lord, and
My lord, may kindly peruse this order, my lord. This case was filed in the year 2023, my lord.
Lordship, before that, kindly peruse page
My lord, may
45,
kindly peruse
Lordship.
the order before they make a submission, my lord.
You were there, Mr. Thor. Where is Mr. Thor?
He is representing the department.
This case was filed in 23 and the OM is of 24.
September 24.
And this case which I have.
You serve a copy.
Minor. He was minor, Lord.
Hmm?
He was minor. Page 45 may kindly peruse of the writ petition. The serial number 15, Lordship.
45.
Yes, page 45 of the writ petition, Lord.
15.
Yes, 15, Lordship.
18 years. Less than
Jinkai
18
Po
years.
Kabui, Lordship.
Yeah.
Executive Engineer PWD. Age at the time of application was less than 18 years.
Yes. So, and Santos.
Obviously, Lordship, N. Santos is their lordship, but the minor, how he can be that one?
Therefore, and Santos.
Yes, Lordship.
But this order, my lord, this order in this case, my lord.
No, is this order also in the case of?
No. This is filed in 2023.
Is it also in the case of a minor?
Sir, my lord, suppose that my lord, is settled. My lord cannot correct it. There is an order, my lord.
In that case, if they are not considering to this order, my lord, let them file the affidavit, my lord. Because by this means of this order, my lord, this is a case filed in 23 and they have agreed to this order, my lord, of the coordinate bench, my lord.
My lord, we are on merit now, my lord. These are minor, my lord.
This order which was passed is also in the case of a minor. No, this WPC 1274. Probably not.
No, my lord.
But the coordinate bench, my lord, has said that we are not going into the merits of the case, my lord. My lord may kindly peruse the order passed on 3rd of.
Why don't you consider it? Whatever else you have to do, you consider it as pass order. That's all is there.
I am only on the settled provision of law.
Huh.
My lord, Supreme Court has settled ballot that my lord cannot claim. And thereafter, my lord, this honorable court has passed an order in support of the
Yeah, there
We'll
is
have it
nothing
next
of
week.
lordship, minor.
Otherwise,
Nothing is their lordship.
let them file the affidavit, my lord. If they-
So you
Will-
place the judgment of Prapan Soitia.
Yes, lordship.
We'll take it up at 2 p.m.
My lord.
Okay, lordship.
2 p.m.
Yes,
Or
lordship.
any other day, my lord, because
Let the judgment come.
Yes.
My lord, so
At 2 p.m. Lord.
or on Monday, my lord. If my lord is sitting on Monday also.
Let the judgment come. We'll give you time if you have difficulty.
Yes.
We'll accommodate.
Read petition number 6916 of 2023.
Right.
6916 of 2023 upon Saitya versus Sultan Assam. Order dated 12/12/2023.
All right. We'll take it up at 2 p.m.
Distinctly, my lord.
Peter would like to say. Yes.
In the last day, CGST was directed to furnish collect complete instruction.
Yes. Where is Mr. Odikari?
If not,
MR Odikari, CTC. Roll. Let him come. Or if you can inform him, follow up the matter.
It is a case of appointment of arbitrator.
Huh?
Appointment of arbitrator.
Yes.
May I please, Your Honor, we may be allowed to file a reply.
How much time do you require?
2 weeks, Your Honor, moreover, as arbitration case has been filed by the petitioners at Tinsukia, which is also pending by petition number 02/2022.
Under
It's a case of interim protection, section 9.
Section 9.
This is section 11.
Heard Mr. T. Kolita, counsel. Mr.
A. Rahman.
A. Rahman appears on behalf of sole respondent.
Full response.
How many? All the respondents.
Yes, Your Honor. Yes, Your Honor.
All the respondents. Please have 2 weeks time be granted to file the objection. Please start with straightforward.
May I please, Your Honor? Order dated 27/11 and order dated 10/1/25.
Some time may be granted. As per the last order, we had actually intimated the commandant in the 22nd Battalion, taking the present status after submission of all the pension papers by the petitioner. Now that instruction is awaited. Some time is left. The commandant, the battalion, 22nd battalion is situated in Likavali, Dhemaji.
In terms of the earlier order, it is 27/11, 2024, 10/1/2025, 17/2/2025. Petitioner had appeared before the concerned authority and submitted all relevant documents. This is reflected in the subsequent order dated 19/3/2025. And Mr. D. Bora, learned counsel, appearing for the response for further time. His instruction is taken after 2 weeks.
So there be fixed, my lord, otherwise the matter is getting late.
28, 28.
8th of May.
Highly obliged.
Later, we have appeared on behalf of October 2 to 5. I pay for 5, my lord.
Mr. H.R. Ahmed for the petitioner, Mr. D. Saiwala submits that he has entered appearance on behalf of respondents 2, 3, 4, and 5.
Yes.
He prays for
3 weeks time.
3 weeks time. File is active. It's taken after 3 weeks.
Interim order is there, my lord.
Interim order passed earlier will continue.
Right.
May I please, my lord? My lord, I am on behalf of Mr. DC Bora, my lord. He is physically not well, my lord.
Prayer is made on behalf of Mr. T.C. Bora to that he is disposed and seeks an adjournment of the matter. Mr. A. Sharma, the counsel for the does not object to the prayer. It's after 2 weeks.
My lord,
Right.
Okay, I have received a signed copy of the affidavit today, lordship. So I'll file it accordingly.
Mr. S.P. Das to the petitioner, M.S.D. Bora, standing out with the department. That the affidavit will be filed today.
Today, lord.
They will be court of the day. Let the matter be listed after 2 weeks, enabling Mr.
Date, my lord. Date.
S.P. Das. You want to file a reply or not?
Okay, I'll file a reply immediately.
By which time the reply will be filed? Matter be deferred. To be listed after 3 weeks, enabling Mr. S.P. Das to file reply. Right? It's on 26th.
Yeah.
Okay. Mr. Bob A. Boro for response. Arbor.
Obliged, my lord.
Appointment of arbitrator made on the last occasion, respondents of time to file their affidavit. That has not been filed.
No affidavit has been filed by the respondent, nor is the respondent represented by any by the council. When the matter is called up, Mr. H.K. Sharma, if you the petitioner, matter therefore deferred be listed again on 14th.
Much okay. My lord, in item number 29, my lord, there was the interim order, my lord. It will continue.
Interim order will continue till the next 8 weeks. Yes.
Earliest you also dismissal from service, so affidavit is required, no affidavit is filed.
Lordship, today is a Thursday after notice, lordship. We are yet to receive the instruction.
Mr. Your name?
UK data.
UK data appears for the petitioner and appearing for the respondent. That corrections are not appearing. She prays for 4 weeks time. Let the matter be listed after 4 weeks, enabling the respondents to complete their instructions.
मोस्टली में काली फिक्स डेट है
2nd of June.
ऑफलाइन
None appears for the parties of the vote. Extends deferred to be listed after the yes.
Please, Your Lordship, Lordship, the respondents have filed rejoinder. We will file reply, Your Lordship.
You want to file a reply?
Yes, Your Lordship. Your Lordship, Lordship, there is an interim prayer staying the matter.
You file your reply. We'll consider the matter. How much time do you want?
Lordship, 2 weeks.
We'll keep it after 2 weeks. You file your reply. What is the matter about?
Matter is about transfer, Your Lordship.
Transfer order. You have not joined
No, Your Lordship. I have not.
without an interim order.
No, I could not join due to some personal problem.
Whatever it is. You file your reply within 1 week. We'll post the matter in 2 weeks.
21st of May, if it is not inconvenient to the board.
21st.
Deeply applies,
21st May, enabling the council for the petitioner to file reply affidavit to advise. The affidavit filed.
Yes, our appearance may be
additionally assisted by MS.
I am a senior counsel. I am appearing for the national banking, housing bank.
Senior counsel, assisted by MS R. Purva. Yes, the respondent number. When names of the council to be reflected in the court. I think.
Deeply applies.
MS so appears on behalf of or innovative.
Highly applied.
please not.
My instruction is that there is no DP pending against the petitioner. And an amount of 8,83,000 is the GIS amount has been paid to the petitioner. And Lordship, he is requested to furnish her documents for regular pension. She is not submitting. This is the my instruction.
Lordship, she has gone so many times to submit the documents, but they are not accepting on the ground that criminal proceedings are pending against.
My instruction clearly says, Lordship, this office tries several times to communicate with Timothy Tulideka for submission of relevant documents.
Used to be submitted before whom?
Before the Lordship, Chief Engineer.
What documents are necessary?
In fact, Lordship, I am told, Lordship, even service book is with the petitioner.
How?
Copy of the service book she has obtained, Lordship, not the service book. Okay, that with payments she has received. No, Lordship, it was with, I have specifically stated in my paragraph, it is what with Rotneshwar Deka, who was the senior assistant of the irrigation department. Lordship.
All right, you file a representation, you submit a representation along with all the documents before the authority.
We'll submit within a period of 7 days, Lordship, and direct to pay the provisional pension after 30 days from submission of it.
First you submit it, then we will pass order.
Yes.
Mr. A.T. Chaudhary appears for the petitioner. Mr. N. Upadhyay, study counsel for irrigation, submit that. Huh?
Oh, that's good.
That the GIS form able to the petitioner has already been
yes
paid. And
pension, gratuity, leave salary, all these things are not paid late.
The other service benefits like pension, gratuity, leave salary, etc. have not been paid. Accordingly, the petitioner is seeking specific orders. It is further submitted that although he had approached the authorities to submit the relevant document, the same were not received refused to be received by the department on the ground that there is a criminal proceeding pending. Whereas Mr. N. Vaidya on the other end submits that no such person has been the department. According, we permit the petitioner to file a proper representation before chief engineer, irrigation party, and submit all necessary documents or copies thereof. And the office of the chief engineer will receive the same state document upon same thing filed with necessary endorsement, and thereafter the same copies of the same representation be filed before the further order, if required, will be passed on the next day. 28th.
28.
Obliged.
Obliged, no.
May I please, Lordship? Lordship, recently this honorable court passed a judgment similar to the petitioner, my lord.
That will not apply. The 3-4 judgment, I believe. है
I see it. Ah, see it. 342.
Is it covered?
No, Your Lordship, it's a 3-4 judgment. In that judgment, that OM of 18-9 was challenged. Here, this case is somewhat different, which is a 23 matter. Here, the main contention of the petitioner was that the DLC.
So there is another matter we just saw by another coordinate bench relying on this.
No, that was a different matter. That was with regards to minors. This is not with regards to
No, that is not with minors. How can it be minors? Yes, Mr. Dhar, we have just seen that order. What is the order?
Belleg judgment, Belleg.
Yes, this one. Yes, Mr. Bora, have a look at.
এইটো আপোনাৰ এইটো মেম্বাৰৰ ওপৰত আপোনাৰটো বেলেগ এই সেকেন্ড প্যারাগ্রাফ 3 নম্বৰ OM 18/9/2020
This is a different, because here in this matter, in the present matter, what has happened, he has actually challenged the SLC's rejection. Now, his main ground is just simply that the DLC had recommended his case on 29/4/2017. And as per my instruction, Your Lordship will note the date 29/4/2017, the DLC had recommended his case. But just prior to that, on 27/2/2017, the SLC had considered his case, and they had recommended the names of 2 candidates. And as per this instruction, which is of 2023, SLC, the government is also considering the vacancies in other offices under Revenue and Disaster Management Department under clause 15 for appointment of the Governance Command, that is the petitioner. That is of 2023, 15. After that, the matter did not get listed. No, with regards to my inspection, Your Lordship. Perhaps this matter, present matter, Governance Command. So at that point of time, Your Lordship, 23, that's what I have to get the updated instruction. Now, what would be the scenario? Whether his case, yes, I understand, Your Lordship. I am just saying, like, in terms of, I have to get the updated instruction as to now what would happen. 2 years, yes. That's why I'm saying I want, Your Lordship, I want to get, no, Your Lordship. I want to get the updated instruction. That's why I placed. Your Lordship. Just, if Your Lordship may grant me some time, let me get the instruction as to what would be the. Yes, Your Lordship. Right. Your Lordship, I just want to apprise this court that I have the old inspection now to get the present inspection, the updated inspection. Your Lordship, Your Lordship, I missed out on that particular aspect. Your Lordship.
Now, the petitioner was appointed as medical and health officer in 2014, my lord, and thereafter in 2017, he tendered his resignation. However, before it was accepted, he withdrew his resignation on 27/7/2018. But his application for withdrawal was not accepted, allowed. So thereafter, on 28/2018, he also made another application, which was also processed, but not decision was taken, and it was lost during the process of digitization of files. And then in 2022, my lord, he made another application which was accepted. But your lordship may kindly come to the page 107, that is the impugned order, where it the last part, clause I, the last. The period of absence with effect from 1/1/2018 till the date he resumed his duty at Moriani CHC, Nagajanka will be treated as no work, no pay, and the absence period will not be calculated for any purpose whatsoever. So his seniority and increments all gone. And his resignation was never accepted. Before it was accepted, he filed for withdrawal. He withdrew.
My lord, kindly peruse the order at page 107, my lord. No, my lord, I have not, we have not received the instruction, but otherwise, my lord, this order
Speaking
itself
order,
says, my
yes.
lord, page number 107, my lord. The speaking order by which he was allowed to resume his duties after tendering resignation, my lord. Whereas Dr. Panjal Pratim Gogoi was appointed as so, whereas Dr. Panjal Pratim Gogoi joined Moriani CHC Nagajanka Jorhat on 28/8/2014. Whereas Dr. Panjal Pratim Gogoi tendered his resignation from service on 1/12/2017 with a notice that he will continue his service till 31/12/2017. Whereas Dr. Pranjal Pratim Gogoi applied for withdrawal of resignation and to continue his service as Medical and Health Officer 1 on 28/2018 and again on 21/9/2022. Whereas the resignation of Dr. Pranjal Pratim Gogoi was not accepted by the Health and Family Department as per office record. Whereas it is important, my lord. Whereas Dr. Pranjal Pratim Gogoi has submitted an affidavit with the following declaration. Period of absence with effect from 1/1/2018 till his rejoining, if approved by government, will not be claimed for any purpose. So he has already, before resuming his duties, my lord, he has submitted an affidavit, and on the basis of this affidavit, this order has been issued, my lord, and he has been allowed to resume his duty, my lord. He will be in service for a minimum 10 years under Swento. Whereas there is acute shortage of doctors in the rural areas of Assam. Now, therefore, the government in Health and Family Welfare Department, in the interest of public service, is pleased to allow Dr. Pranjal Pratim Gogoi to rejoin his service and Medical and Health Officer 1 at Moriani. For any other purpose, my lord, for seniority or for pension purpose or, my lord, he has submitted an affidavit. Yes, my lord.
I was forced to file.
Yes, my lord. My lord, once he has resigned, my lord. Yes, my lord.
Resignation was.
Yes, my lord.
Yes,
Yes, my
I'm
lord.
not claiming payment.
Because he was not in service during that period, my lord. No, previous period will be counted probably, my lord. Period of absence. Only the absence period will not be counted, my lord. Yes, my lord. For the purpose of pension or seniority, my lord. For the period of absence, that his earlier period will be considered, my lord. Earlier service period prior to his. My lord, only on that condition, my lord, he was allowed to resume, my lord. My lord, otherwise also, otherwise, my lord, after tendering resignation, rule doesn't permit to allow him to resume his
No, my
duties, my lord.
resignation never accepted. Well, it was never accepted. Before it
Because
was
after,
accepted,
as per rules, my lord, after submission of resignation, my lord, normally a person is not allowed to resume his duties, my lord. Yes, my lord. Because of that, my lord, he rejoining also is not in the rules, my lord. Because after, with that condition only we have allowed, my lord.
My lord, if the resignation is not accepted, I have right to. I am entitled to rejoin my service. Anytime I can withdraw my resignation if it is not accepted.
But he has not withdrawn his resignation.
Yes, I have withdrawn. The speaking order itself says that I have withdrawn.
Applied, my lord. Yes, my lord. That was not, my lord, and thereafter this order has been passed, my lord.
Yes, never accepted.
Yes, my lord.
There is some urgency, my lord. If the petitioner wants to appear in need for PG and it requires continuous 5-year service for in-service doctors, my lord, then last date is 7 May. My lord, this is speaking order, your lordship can dispose it. But last date is. Yes, my lord. But a need requires that for in-service doctors.
No, that requirement. Yes, my lord. I'll
My
file
lord,
it, my lord.
kindly consider this aspect. My lord, all us. Can you make an observation that I may appear in that? No, my lord. For the time being, the health department can give me a certificate.
No, no, that cannot. Oblige, my lord.
August 24, my lord, he retired, my lord. Nothing has been given to him. My prayer was that your lordship will dispose of this matter with a direction.
My lord, I received some instruction, my lord. I need to file affidavit, my lord.
No. I've been retired, my lord. It was, your lordship will kindly see page 43. Departmental proceedings, my lord, it concluded. And ultimately, last paragraph, further the government of Assam is pleased to order that the period under suspension of state so and so shall qualify for pension and the pensionary benefit only, and the payment and the pay and allowances for the suspension period shall be limited to the substance allowance paid to him or ordered to be paid. So with this is the DP closed. COVID benefit. Bishop, 10%. My lord. No. Provisional pension was paid, that was stopped from February. Let them file the affidavit, your lordship will dispose of the matter.
Order.
February. Yes. That is also one of the grievances. Let them file the affidavit, yeah, I'll pray your lot.
where such a belief of the SSC, a mala fide belief, particularly where such a belief of the SSC, a mala fide belief, particularly when such a belief was emanating from the view taken by division bench of the tribunal. We know that issue of valuation involved in this particular matter is indeed one where two plausible views could coexist. In such cases of, in such class of cases, disputes, interpretation of legal provision, it would be totally unjustified to invoke the extended period of limitation by considering the SSC's view to be lacking bona fides. In any scheme of self-assessment, it becomes responsibility of the SSC to determine his liability of duty correctly. Determination is required to be made on the basis of his own judgment in a bona fide matter. My lord, the common thread which runs through all the judgment is, my lord, that strong words has been used in the statute like fraud, collusion, misstatement. Mere understanding that what had happened, my lord, they have taken the figures from my income tax return. And income tax return, I'll have to show my gross turnover. Otherwise, my lord, under the megas exemption notification, these are exempted. And I have shown in a joint venture where the petitioner is a party, whereby the same assessing officer, my lord, he has been exempted. So where is the question of separation? There is one judgment, of course, of the tribunal where all these views have been taken. This is exactly in the context of 73. It's a 2024 SCC online SysStat 1452. My lord, if your lordship kindly comes to para 16, where, my lord, section 73(1) of the Finance Act is quoted. Then in para 18, that Purushottam Pharmaceutical, that 1995 supplementary SCC is quoted. Then, my lord, in para 20, that other case is quoted. Eventually, if your lordship kindly comes to para 29, in para 29, relying upon the Reliance case, my lord, this view is taken. In Commissioner of Central Excise versus Customs versus Reliance Industries, the Supreme Court held if an SSC bona fide believes that it was correctly discharging the duty, then merely because the belief is ultimately found to be wrong by judgment would not render such a belief of the SSC to be bona fide. If a dispute relates to interpretation of legal provision, it would be totally unjustified to invoke the extended period of limitation. Supreme Court further held that in any scheme of self-assessment, it is the responsibility of the SSC to determine the liability correctly, and this determination is required to be made on the basis of his own judgment and in a bona fide manner. So paragraph 23 is quoted, my lord. Now, if your lordship would kindly come to the facts of this case at para 32. Para 30 to the facts are quoted. Now, para 33, what was alleged by the department? It cannot be alleged by the department that facts were not in the knowledge of the department, since earlier also a show cause notice had been issued by the department to the appellant for the period from so-and-so to so-and-so, proposing demand under the same heads as in the present appeal. There is therefore no reason as to why show cause notice should have been issued beyond the normal period of limitation for the period from April 12 to March 13, nor there is any justification for issuing a show cause notice dated so and so for the subsequent period from April 13 to March 24. It is therefore clearly a case where the facts were in the knowledge of the department and department cannot allege that facts has been suppressed. In any case, if it is assumed that the facts were suppressed by the appellant, then too no reason has been assigned in the order passed by the Joint Commissioner or the Commissioner appeal, and as such suppression was with an intent to evade payment of service tax. This apart service tax has been demanded on the basis of profit and loss account and balance sheet, which are public document which the department could have ascertained. The issue involved in this appeal also relates to interpretation of law. The decision referred to above have clearly held that in such circumstances, there can be no separation of facts with an intent to evade service tax. So eventually, my lord, the orders were set aside. Here also, my lord, income tax figures were taken note. It's a pure and simple case, my lord, where in terms of the exemption notification, we are exempted. Therefore, we have not shown in our returns because it's exempted. Now they have added it. Now they say that how can they invoke the extended clause? Therefore, my lord, in terms of the law laid down by the Honorable Supreme Court, at the not to speak of any question of merit, my lord, the so-called notice is barred by time. So in such matters, my lord, why should I go to the appellate authority, my lord? Even otherwise, my lord, no, it's a jurisdictional issue. Limitation is a question of jurisdiction. That's my humble thought. Deeply.
Individually, I'll submit my written submission with a copy to the mail and now oral lordship, Laura, at this stage I can argue on that landed scenario result. The main contention is that we have taken data from the income tax department. But see, service tax is a self-assessment procedure. The SEC has to disclose all this. Unless he disclose, it is difficult for the department to accept it. It is primary duty of the SEC to disclose everything before the authority while filing a return in form of DT.
Yes,
Order has been passed.
Yes,
Yes.
they reply.
The authority has considered everything. I'll point out from the order. The common question in all that is the mother date. Lots. No, lot. Yes, on the same day I will submit. Yes, sir. I'll
Name of the party, subject matter, show cause notice, the order.
yes, I'll submit. In some cases. Yes, sir. I'll share with it. Oh, yes, sir.
My lord, item number 35 is a similar issue. I have already filed my request for it. And item number 38 also same issue. I may be allowed to file within 1 week. I request for it. So it's subsequently that will be taken. I will file. You got it, that's what.
27 for again.
28 तारीख.
27th mail.
Deep.
Yes. Yes. What? Within 1 week.
It is your lordship. My lord, on the last occasion I submitted one judgment, my lord. Because of non-communication of SCR, my lord, petitioner was denied promotion. Affidavit, no, my lord.
Lordship, matter may be taken up at 2 law. RDB. Okay.
I'm sorry, I was there, my lord. For the state, my lord, item 48, my lord. 48.
Yes, very well. Lordship, in this case, there is two case, Lordship. One is of 2026, right? 2016, Lordship. Here, Lordship, the petitioner is praying for regularization. During pendency of this case, Lordship, petitioner retired, Lordship. And the second petition has filed, Lordship, item 64, Lordship. In this case, Lordship, petitioner is praying for his pension, Lordship, even though he is not regularized. PNRD, Lordship.
PNRD department sending something. I'll inform.
And regarding pension, Lordship, he has continuously 29 years of service, Lordship. Thereafter, he retired, Lordship. I have also annexed the judgment of not, Lordship. Even though not regularized, Lordship, he is entitled for pension, Lordship. I have annexed the judgment of division bench, Lordship. He has, in additional affidavit, Lordship, page 59, Lordship, in additional affidavit, Lordship, this judgment is cabaled. Solely Bajbapar, Lordship. Yeah, Lordship, in details, Lordship, the that Lordship, the ingredients of the preconditions, Lordship, which is required for Lordship pension, Lordship, that has been explained by this judgment, Lordship, and the here, Lordship, the in the Dolly Barbujari case, Lordship, uh, uh, she was appointed as his will, Lordship. They are not, and she was not regularized, Lordship, and she was continuing only 14 years of service. Till then, Lordship, still also, Lordship, she was the division bench says that she is entitled for pension, Lordship, and she was fulfilled these three conditions, Lordship. Paragraph, Lordship, 5, 7, 12, 13, 18, and 20 are the relevant. Mary. In this case,
Yes, my lord. My lord, actually, what happened, my lord? Technically, the old matter, my lord, that was infructuous actually. The 14 matter, because that was filed for regularization, my lord. 2016 matter, yes. He already retired, my lord. Now, lordship, the government is decided, my lord, to give him some relief, my lord. Therefore, it was placed before cabinet, my lord. And thereafter, my lord, what happened? Cabinet raised some queries, my lord. Now again, we have prepared a proposal, my lord, and it's awaited, my lord, for approval of the higher authority, my lord. Thereafter, it will be placed before the cabinet, my lord, so that he can be given relief, my lord.
Lordship, in this case, Lordship, my learned friend is submitting regarding the old case, Lordship. The old case was placed before the Lordship, cabinet, Lordship. Regarding pension, the cabinet, no cabinet memorandum was prepared, Lordship. Nothing has been done, Lordship.
My lord, if his case
Even if
was
Lordship
regularized, my
is
lord,
not
that
regularized,
will impact on the pension also, my lord.
Yes.
After regularization only, my lord, his pension case can be moved, my lord.
So my submission is the, yes, Lordship. May I read, Lordship, this chapter? Paragraph 5, Lordship. Before proceeding any further, it may be appropriate now to refer to some of the provisions of the Assam Services Pension Rules 1961. Rule 9 defines pension. Rule 11 defines superior service to mean any kind of service which is not class 4 service. Rule 111 provides the service of an officer does not qualify for pension unless the service is under the government. The employment must be substantive and permanent, and the servant must be paid by the government. By the proviso to the rule, the governor is empowered to declare a service to qualify for pension, even though the service does not fulfill the qualification criteria laid down under Rule 31. So Rule 36 additionally provides that unless an officer holds a substantive office on a permanent establishment, it shall not qualify for pension. It is also provided that temporary or occasional service of rendered in a non-pensionable establishment shall not count towards pension. Rule 37 entirely indicates that an establishment which is employed for a period exceeding 6 months in a year is a permanent establishment, and that service in such an establishment, including a period during which the establishment is not empowered, qualifies for pension. In Chapter 4 of the rules, conditions of grant of pensions are prescribed. Under Rule 68, pensions are divided into 4 classes, and superannuation pension is dealt with by Rule 93. When an officer is compelled by a rule to retire at a particular age, superannuation pension is payable to him under Rule 93, whereas retiring pension is granted to an officer who is permitted to retire after completing qualifying service, superior service, as may be prescribed. In the instances since the applicant was Lordship, no Lordship. Here, Lordship, petitioner is ad hoc appointee, Lordship, present petitioner. And in the case of Lordship Dalip Pujari, he will no Upendra is regarding Lordship regularization, Lord. No Lordship. And on the basis of this judgment, there are 2-3 judgments also there. I may be placed. And recently, Lordship, the Supreme Court also, Lordship, no, only one Lordship, Supreme Court has Supreme Court judgment. Yeah. Lordship, then the date may be this, Lordship, I will satisfy your Lord. Then it is the next week, Lord.
I know.
Ma'am, please, Your Honor. For item number 63.
My lord, the petitioner was appointed as CRPF personnel after due interview. After serving nearly 4-5 months, the person became a little mentally imbalanced. So there was medical examination and the medical authorities said that he is unfit to serve as combat force. Now we have filed a writ petition against that order because I was terminated. That Lordship may see the High Court's order, page 31. Thereafter, my lord, the authority suggested me to go on yoga and exercise, etc. That is page 34. Even then, yes, that ultimately they rejected my prayer. That may be seen page 35. Property portion, page 36. Lordship may see on going through.
Lordship, kindly pass over the matter for the time being, Lord. My senior is in legs, Lordship. In the Segan, Lord.
Otherwise, pleadings are complete in the matter. I was praying, my lord, that if the matter can be taken up at 2, she is having some difficulty. I didn't have time to go through it. I can do it at 2. If I get some time to go through the brief once again. Only hearing them, my lord. Since the man is out of job, my lord. Holiday to 15. Deeply obliged.
In this matter, an additional affidavit has been filed, my lord, served upon me just now, my lord. Will be taken up next week, my lord. Let me have my answer, because otherwise we have filed our affidavit, my lord, pertaining to a selection. Can it be on 15th or 16th, my lord? Excellent.
Well, I wanted to say something, my lord. Otherwise, I'm going to complete, my lord.
I have certain judgments reserved for Lordship and arguments on the limited point that whether oral hearing was necessary before passing the interim blacklisting order, holiday listing. These are the cases, my lord. I'll just briefly refer to certain paragraphs. I will provide some. I'll read it out. So my learned senior counsel can also look at it. Well, the first case is Madhya Pradesh Industries versus Union of India and others. This is cited as 1966 1 SCR. Page 473. The relevant page is 473. Madhya Pradesh Industries. There will be only a portion of that. That is the last paragraph.
Although this is an order of a quasi-judicial tribunal, however, this judicial trend is to equate the orders and the opportunities granted by quasi-judicial tribunal with that of an administrative authority as well. My lord, may come to the last paragraph of page 473. As regards the second contention, as my lord found it, 473. As regards the second contention, I do not think that the appellant is entitled as of a right to a personal hearing. It is no doubt a principle of natural justice that quasi-judicial tribunal cannot make any decision adverse to a party without giving him an effective opportunity of meeting any relevant allegations against him. Indeed, Rule 55 of the rules, Court Supra recognizes the said principle and states that no order shall be passed against any applicant unless he has been given an opportunity to make his representations against the comments, if any, received from the state government or other authority. Yes, ma'am. I'll be coming back to the judgment cited by the learned senior counsel here. This is only on the reason that not necessity of personal hearing. And this point, my lord, the next judgment is Carborundum Universal Limited. This is 1989 supplementary to SCC 462. Relevant paragraph is paragraph 6. Second page of the judgment. This is again under the Income Tax Act, section 220. Blacklisting. Well, the question of hearing before when the proceedings are quasi-judicial, whether the question of oral hearing is required. Hello. Malor. Malor, that is why I've taken this question first. On what person hearing is necessary? Yes, my lord, and my lord, the judgment referred to by learned senior counsel, this is SBI versus Rajesh Agarwal, 2023 6 SCC 1, my lord. That is at page paragraph 54 of the said judgment, my lord. That is the point herein Justice Chandrachud and Justice Kohli. This is the recent judgment cited. This is 2023 6 SCC 1 in the list of cases given by the petitioner. Paragraph 54. This will be page 512. 2023 6 SCC, SBI versus Rajesh Agarwal. Page 512, paragraph 54. Last paragraph, I think. In a decision of the three-judge bench of this court in Swadeshi Cotton Mills versus Union of India, 54. This is marked as 54. I do not have the judgment with me. This is page 512, last paragraph. It is marked as 54. Yes, ma'am. Paragraph 54, it is in my, I'm reading online, my lord. This is written as 54. Last paragraph, if my lord may turn to the last. Page 512, yes. Not the judgment, page 512. I'm reading from SCC online, my lord. I will, if I may read from the copy which the senior counsel for convenience sake of everything. Well, I'm sorry, I apologize. This is SCR, so there would be a slight difference here. I will point out. This is SCR. We come to page 37, 36, last paragraph, paragraph 68. paragraph 60, in a decision of the three-judge bench of this court in Swadeshi Cotton Mills versus Union of India, the issue was whether the central government was required to comply with the requirements of Audi Alteram Partem before it took over the management of an industrial undertaking under so and so section of the Industrial Development Regulation Act. R.S. Sarkaria Justice, speaking for majority consisting of himself and Justice Desai, laid down the following principles of law. In short, the general principle, as distinguished from an absolute rule of uniform application, seems to be that where a statute does not, in terms, exclude this rule of prior hearing, but contemplates a post-decisional hearing amounting to a full review of the original order on merits, then such a statute would be construed as excluding the Audi Alteram Partem rule at the pre-decisional stage. My lord, therefore, the broken down in substance is where the statute, in this case, the blacklisting guidelines, does not exclude, is silent about the rule of prior hearing, but contemplates a post-decisional hearing amounting to a full review, in this case being the remedy of appeal before the appellate authority. Then, yes, my lord. Conversely, if the statute conferring the power is silent with regard to the giving of pre-decisional hearing to the person affected, and the administrative decision taken by the authority involves civil consequences of a grave nature, and no full review or appeal on merits against the decision is provided by, then the courts will be extremely reluctant to constitute such a statute as excluding the duty of affording even a minimal hearing shorn of all its formal trappings and dilatory features the pre-decisional state. That is why, my lord, I reverted to the decision earlier, because the trend earlier was that there would not require to be any decision, oral hearing, at the pre-decisional stage. That was the original trend of judicial decisions. Thereafter, my lord, there came subsequent 2010 a trend of judicial decisions wherein the fair opportunity of hearing included that point of oral hearing in this case. But here, the Honorable Supreme Court has itself clarified there are two particular trends. My lord is aware of the fact that if there is an undisputed question of fact, admitted question of fact, then the question of oral hearing becomes a formality that we leave aside for time. This rule of fair play must not be jettisoned save in very exceptional circumstances where compulsive necessity so demands. The court must make every effort to salvage its cardinal rule to the maximum possible with situational modification. But to recall the words of Justice Bhagwati, the core of it must remain, namely that the person affected must have a reasonable opportunity of being heard. The hearing must be a genuine hearing and not an empty public relations exercise. My lord, the question is that when a show cause notice was issued, when they give a detailed reply to that, and that reply is considered by the authority, would the imposition of a pre-decisional hearing be necessary at this stage? More so, my lord, when on facts, if my lord now comes to the reply notice, they have not asked for a oral hearing at the stage of reply of the show cause notice. That prayer has not been made. I will take my lord to the reply of the show cause notice. It is at page annexure. It is a tabular format reply. It starts from page 60. Tabular reply to each allegation they have made a reply. My lord will permit me to read the entire reply whether there is any mention of a request for pre-decisional hearing. Against paragraph 1, the reply on behalf of AK Interior and Exterior Associates. We would like to humbly submit that the canopy of the filling station was constructed a year ago and has remained structurally sound without any complaints regarding its construction. However, on so and so, we received a show cause notice stating that on 4th of April, a heavy thunderstorm occurred, causing the canopy to shake. Next page, I strongly deny that the canopy shook for the first time on 4th of April, and according to our knowledge and reports, there has been some reparation performed on the canopy by a labor appointed by dealer, which we are unaware of. We strongly believe that the facts mentioned in show cause notice are not true and are fabricated. In reality, the canopy shook earlier, repairs were made subsequently. We have submitted a detailed report regarding this matter to the concerned authority on 23rd April 24. We are unsure whether the actual date of the canopy shaking is being withheld. Since the repairs were carried out by dealers whose standards we cannot verify, we should not be held responsible for their work. We respectfully request an inquiry or reinvestigation of the entire situation by an independent body such as IIT Guwahati. This is the first request. Second, it is to be mentioned that we are ready to hand over documentary evidence proving that the canopy shook earlier to the appointed third-party investigation team in court. Second request is for submission of documentary evidence. Furthermore, they themselves admitted in the show cause notice that there was heavy thunderstorm on the night of April 20, therefore blaming our work is illogical since they acknowledged the occurrence of the storm. Such natural events are beyond our control. Collapse of the canopy was not due to contractual negligence but a natural cause. Case 62. It is also important to note that on the night of April 2024, not only the canopy but many other structure and trees collapsed as well as in that area. We are attaching some local newspaper clippings as an extra one to support this. Against allegation number 2, as all the 3 members of the investigation committee formed by the IOCL belongs to IOCL department itself, therefore it can be termed as an independent investigation. So we respectfully request to the IOCL management to reinvestigate matter to IIT Guwahati. This is an allegation of bias or unimpartiality. Allegation 3, we categorically deny using any substandard or non-standard materials for construction of canopy. We have exclusively used materials from the SAIL brand. PTA reports and test report of raw materials should suggest the same. Material test report to ISL has been attached here and marked as Annexure 2. Allegation 3B, our welding processes adhere to stringent quality checks and industry standards. Continuous welds with proper fusion were ensured throughout. Additionally, we completed the welding as per instructions laid by our department. Moreover, third, kind of the guidelines, I can submit a copy there. No, it has not a part of the pleadings. They have not annexed the guidelines. They have not challenged the guidelines as well. Clause 3 is the show cause notice. Because there is already a facility, that is what we said in the first stage, that if they go for an appeal, we can take a personal hearing there itself. That authority is empowered, that post-decision stage of hearing. Their contention was that the appellate authority would not be fair or impartial. Malord, if that argument is pressed, then what is the guarantee that the original authority would be fair and impartial in a personal hearing? If the appellate authority, who is of a higher rank, would not be fair and impartial to them. So it was initially suggested that they ought to go for a way of appeal and press a plea for personal hearing, along with all other expert evidence and documentary evidence which they desire to submit. That factual remedy still remains open to them. Lordship may grant them the liberty as well, exemption from any limitation period as well. Within 30 days, the appeal process has to be filed within 1 month and to be completed within 60 days. That may be relaxed. We have no objection to that.
Oh, my lord, here I have submitted, my lord, that tells it there, I have submitted several judgments, my lord, that hearing is a must now. Now, jurisprudence has developed, my lord. From Raghunath Thakur, my lord, 89-1 SCC, it says, my lord, that when the case of Blacklisting. Yes, my lord. My lord, I have dealt with that, my lord. My lord, I have dealt with that, my lord. Even blacklisting also, my lord, requires the personal hearing. And moreover, my lord, here I have referred to that judgment 28 SC, my lord, that when there is a fault on the part of the, my lord, the other party, they cannot blacklist me. That 40 part. That is why, my lord, I have submitted. I am submitting, my lord, the editor synopsis also, my lord, regarding my. My lord.
judgment.
Learned was just placing my lord the judgment by 23-6 access page 1. My judgment, my lord.
Rajesh.
Yes. If you also see paragraph 63, my lord.
Yes. Yes.
Last so and so, judgment of this court held that the decision taken by an authority affecting the right to reputation of an individual has civil consequences. Therefore, in such situation, principle of natural justice would come into play. The court held that any order or decision of the authority adversely affecting the personal reputation of an individual must be taken following principle of natural justice. Amply clear that one is entitled to have and preserve one's reputation and has also right to protect. In a case of any authority in discharge of the duties fastened upon it under law reveals into the realm of personal reputation adversely affecting him, it must provide a chance to him to have a say in the matter. In the circumstances, the right to have individual expense or natural justice being adversely considered should really recognize the violation of the same scrutiny of law. Then, my lord, I have already read paragraph 65 and the last paragraph, my lord, the conclusion at page 98.4 that I have read. Now, I have relied, my lord, under that judgment. Well, the first thing here, my lord, my argument was twofold. My lord, your lordship has seen, my lord, that
Can you go back to the conclusions again?
my lord?
Conclusions.
Yes, conclusion, my lord, 98.4. Such a debarment clause under 8.12.1 of the Master Direction on Frauds is akin to blacklisting the borrowers of being untrustworthy. The court constantly held that an opportunity of hearing ought to be provided before a person is blacklisted. So, my lord, I have relied on UMC technology also, my lord, that 21 to STC. My lord, that is the important judgment on this point. I relied on several paragraphs. That is 13, 14, 15, 17, and 19. That is UMC technology.
Yes.
Yes, at the outset, there are 13 melody.
You have relied on para 21.
No, that 21 to SCC page 551.
Yes.
Here, my lord, I relied on paragraph 13, 14, 15, 17, 19.
13,
14, 15, 17, and 19.
This is in so far as the notice is concerned.
This, not only notice, my lord, hearing.
You can come to para 21.
No, para 21, my lord, that's subsequent, my lord. If you also come to paragraph, my lord, 19.
Nineteen.
Yes.
Yes.
Prior to date, my lord, I am coming. Paragraph 17 also. Your lordship may come to paragraph 17.
No, the question is not perhaps of opportunity of hearing.
Yes, my lord.
Question is the opportunity of a personal hearing.
Personal hearing, my lord. My lord, that is what I am submitting. My lord, that I have submitted 2 more cases, my lord. 89, one SCC also. That is, my lord, of the Raghunath Thakur. 891 SCC. Raghunath Thakur case is also important. Paragraph 4, one paragraph. 89 1 SCC 229.
89.
It is civil death, my lord. Supreme Court has constantly said that blacklisting a person is civil death. 89 1 SCC. Paragraph 4.
indisputably, no notice has been given to the appellant of the proposal of blacklisting the appellant. It was contended on behalf of the state government that there was no requirement of rule giving a prior notice before blacklisting in person. Insofar as contention there is no requirement, especially of the giving any notice is concerned, the respondent is right. But it is implied principle of rule of law that any order having civil consequences, my lord, this is that the civil death, my lord, should be passed only after following the principle letters. It has to be realized that blacklisting any person in respect of business ventures has civil consequences for the future business of the person concerned in any event. Even if the rule does not express so, it is the elementary principle of natural justice that parties affected by the order should have a right of being heard and making representation against the order. In that view of the matter, the last portion of the order insofar as direct blacklisting of the appellant in respect of future context cannot be sustained in law. In the previous case, that portion of the order directing the appellant to be placed in the blacklist in respect of future context under the collector is set aside. And so for cancellation, this is different matter. Now, my lord, in this matter, I have twofold argument, my lord. First thing,
See,
my lord,
let us understand one thing.
yes,
We are trying to understand that in a case where there is a blacklisting procedure, you must be given an opportunity. Question is whether it is an opportunity of making a representation or a opportunity of personal hearing. It's one. Secondly, as in the facts of this case, uh, there is a facility of filing an appeal against the order which has been passed, where
now
you'll get
appeal is provided. Appeal is not.
where you'll get a personal hearing.
My lord, that is another aspect of it. My lord, the original, my lord, the authority, if does not hear me, that cannot be cured in the appellate authority. There are many others, my lord. My question is this here, my lord. My first argument was that my liability period was over, my lord, in January 24. January 24, my lord. My lord, your lordship may just hear me, my lord. Because I have referred to another judgment of 23, my lord, 8 STC, my lord. Because first thing, my liability period was over in January 24. Secondly, my lord, IIT has given a report that my lord, drawing has been given which is a fault in there. Then their own finding is there, my lord. That yes, it is my lord. This should be 4 pillars. They have given, my lord, because a B, my lord, yeah, then because in there they have to maintain the things have to be maintained by the owner, not by the company. So they have been 2 pillars, and it cannot withstand the thunderstorm, my lord, of just like there. I have placed their own finding, my lord, in the petition, my lord. I have annexed their own thing, my lord. They are from the affidavit, my lord. From the affidavit, I have placed, my lord. If your synopsis comes, my lord, because in my written synopsis also, my lord, I shall submit it, my lord. I have quoted this.
Yes.
Yes. My lord, first your losses may come to page 176, my lord. The executive summary.
Yes.
Is the third para. On 20th April 2024, at around 2 a.m. in the morning, it was reported that a strong wind blowing with heavy rain has hit the subject area. Due to heavy velocity of the wind, heavy thunderstorm, and heavy fall newly installed canopy structure held in the retail outlet premises, leading to damage the canopy structure so and so. The high velocity of the wind and heavy rain has caused tilting, toppling of the canopy supported by two number of columns towards right side. Now I shall come to my lord. Next, your losses may come to page 181. Last cause of incident. Core design layout, etc. Design was prepared not considering the site specific condition. Wind speed consider 50 meter against actual requirement of 55 meter as per so and so so and so. Drawing not specific about the welding joints. Details of connection between column, plate, main so and so that missing. Now this is one. Now I am coming to another malon. The losses may come to page 184.
184. Yes.
Gaps and lapses. Design not prepared as per site specific conditions. Drawing not specific about the welding joints and details of connection between so and so, so and so, so and so. Now, your losses may come to 8.
Yeah.
Column 8. No records found pre-monsoon canopy drain tax as per policy. Justification for revision of budgetary estimate from column 4 to column 2 would not be produced. So they prepared a design of canopy of 4 column. Thereafter they change it, but they could not put it. This is their own, my lord, report, my lord. Now, what happened, my lord? I have submitted a judgment saying that, my lord, suppose, my lord, that my liability period was over by January 24. Now, this incident happened in April. At that time, it was not my liability period, my lord. Secondly, even if some lapses are there, my lord, that judgment of 23.8, my lord, I have produced. My first case is this, my lord. Second case that comes to 23.8 SCC, page 607. Para 40, last part, my lord. That Supreme Court is very clear, my lord, in this point.
Yes.
The written submission on behalf of comes to
You are reading 23.6 SCC.
23.8 SCC. Page 607.
23.8 SCC.
Page 607. Para 40.
40.
40, my lord, the last my lord, middle port. The written submissions. Your lordship got it?
Para 40 begins with the process of.
No, my lord,
forming
23.8 SCC.
Yes.
Page 607.
Yes. Rajesh Agarwal.
No, isolators.
Oh.
23.8 SCC, my lord. 607.
Okay.
Can you give it?
Yes.
Your lordship got it?
Para 40.
Yes.
Yes.
The middle portion, my lord, the written submission. The written submission on behalf of the respondents do not answer the root question. The matter is how the appellant could have been made solely responsible. My lord, that is the main question, my lord, here. First thing, my liability bills are over. Secondly, even if some test, my lord, but they have their own lapses.
No, these factual metrics, the appellate authority is there to examine.
No, not the appellate authority, my lord. The High Court can see, my lord, that because this is the Supreme Court has said, my lord, that is why. Is solely responsible for delay or default in supply of the communication that is so and so when respondents themselves inform the appellant that taking balance of delivery being heard in length and breadth of the arguments on behalf of the respondents, it has nowhere been pointed out if such further instruction was ever issued to the appellant before issuance of the cancellation order dated 19/11/19 and 21/11/19, as also before issuance of the so-called notice so and so. That being the position, we are clear of the view that debarment order had been issued against the appellant with due regard to the undeniable factual situation that the entire blame could not have been. Well, this is that. entire blame could not have been posted upon or shifted towards the appellant. Hence, the imputing order debarring the appellant is got to be sustained. Well, here, how they can put the entire blame on me, my lord? First thing, there is a natural calamity. Second, their own defective drawing, my lord, and other things are not there. Their own, my lord. The IIT has also said, my lord, that the defective drawing, my lord, and it is not site specific. Site specific, they themselves say, my lord. Their own, my lord, report has said. It's not a site specific.
You erected it.
My lord, I erected it because I have been given, my lord, the order. I have to, because it's a B site. B site is to be maintained by the owner, my lord, not by the company. That is why, my lord, they have reduced the cost. Otherwise, my lord, in their own, my lord, A site, they always give 4 pillars. It's a B side, they reduce the cost, and that is why they change the drawing from 4 pillar to 2 pillar.
You are a reputed company for construction, isn't it?
Yes.
So seeing the drawing, you know whether
My
this
lord, that
drawing
is
is.
that is not my lookout, my lord.
Right.
Because I cannot object to that, my lord. Because they have changed it. Because it is side B. My lord, I have to comply with that.
I'm not saying that you are.
Yes.
What we're trying to understand is you are a person who is well versed in the works of construction.
Yes.
So looking at the drawing, you can make out whether this is a safe drawing or it has met with all the standard requirements or not. If you had noticed something that it was not as to.
My lord, can a contractor do that? My lord,
What to
that
do
is,
that?
I'm putting question to myself, my lord. Can a contractor do that? My lord, it is the contractor who has to do everything as per the drawing provided by the owner. Owner. And now this judgment is very clear. First argument is this, my lord, that first my liability period was over by January 24. Incident happened, my lord, in April 24. And thereafter, my lord, when they themselves made an inquiry, and there it was found that their drawing was defective, and moreover, it is not a site specific, my lord. So that site is concerned, my lord, because it's a natural calamity was there, and due to natural calamity only it has fallen down. So after the liability period was offered, my lord, I have been putting the entire blame and blacklisted, debarred. Can that be done, my lord? Supreme Court says no, my lord. This cannot be done. And this is, my lord, my question, my lord. And secondly, my lord, the question of appeal does not, my lord, here, when justice violation is there since 1998, my lord, that it has been followed. I have referred to the latest decision of this court, my lord, Supreme Court, my lord, in this regard. That is not the thing. Where natural justice violation is there, my lord, yes, it can be. 2012, 2216, SCC 447. I refer to. That is coming from 1998, my lord, the 3 principles, my lord. That is. So my submission is this, my lord, that this is not so, my lord, and these points are I have noted down, my lord, in my written synopsis, my lord, and I'm giving my learned friend.
Yes.
Just one additional points. I have given the list of judgments. There is one case, Nirma Industries, paragraphs 30, 33, 35, and 38 deal with the issue of when the appellant itself does not.
Where are your judgments?
Look, I have given for the brief, madam.
One is Jesus Sales,
Jesus Sales is there. That is on the issue of it is not
Nirma Industry.
Nirma Industries,
Yes.
paragraphs 30, 33, 35, and 38.
Please take us through that.
Paragraph 30, page
Reference to this,
paragraph 30, 2013, 3 SCR.
Paragraph 30.
Paragraph 30, 30, 33, 35, and 38.
Yes. Yes.
Paragraph 30, in B. Karunakar and others, supra having defined the meaning of civil consequences, this court reiterated the principle that the court tribunal should have mechanically set aside the order of punishment on the ground that the report was not furnished to the employee. It is only if the court or tribunal finds that the furnishing of the report would have made a difference to the result in the case that it should set aside the order of punishment. In other words, the court read a person challenging the order on the basis that is causing civil consequences would have to prove the prejudice that has been caused by the non-grant of opportunity of hearing.
Here
In the
the
present
prejudice is apparent.
Yes, my lord, in the letter dated so and so, the appellants have not made a request for being granted an opportunity of person hearing. Therefore, the ground with regard to the breach of natural justice clearly seems to be.
This is on a different.
Only on the ground whether when the appellant does not make a request for person hearing, can it be deemed to have been a.
This is perhaps as per the rules or something, I do not know.
My lord, again, in 33 also, this is related to Land Acquisition Act, a different act statute. Darshan Lal Nagpal versus Government of NCT. Where
No, if it is your case that he did not make any request for a personal hearing, we'll ask him to make a request now. You go back and give him a personal hearing and conduct it afresh.
My lord, second part is that had he made a request thereafter, the authority being an administrative authority, after having passed the order of blacklisting, is divested of the function. Thereafter, it cannot review its own order even on a request unless the statute permits it.
No. Is it your case that had he made a representation or a request before the authority that he requires a pre-decisional hearing, you would have considered the case?
No, my lord, my case is that the order is not informative for reason of non-grant of a person hearing.
That is one thing, but you have relied on this Karunakar, that therefore I am asking you.
No, well, this case is that it is not infirm on the basis that no personal hearing was granted because the appellants did not request in the first place. That is one point. But second point, my lord, if that case is regarding the 2021 2 SEC 551 retired by learned senior counsel, my lord, EMC Tech. In that case, my lord, it was the Supreme Court held in paragraph 13 and 14 that the notice must be adequate, particularized, not ambiguous. It must mention
You show us
yes, madam.
that it is sufficient to meet the requirements of natural justice if a notice is served. Personal hearing is sine qua non, not required.
My lord, that is the question here in all throughout the Honorable Supreme Court is saying that the minimum opportunity, not the liberal or an expansive opportunity of person hearing. Because, my lord, there are two components of hearing. One is the written representation, one is the oral hearing. Both of these, my lord, in a case of.
It's a very simple proposition.
Yes.
You are arguing your case for your client.
Yes.
Why not submit written arguments and close the matter? Why do you want an oral hearing from the court?
In fact, my lord, on a technical issue, written arguments are better. They preserve the argument for posterity.
That's a different issue. If that be so, then you submit your written arguments, we'll close your hearing.
That is
the whole purpose of giving an oral hearing is for the authority to understand whether the decision or two circumstances, what decision is required to be taken in a given set of circumstances. And the decision prima facie which they have decided to take by issuing a show cause, whether is required to be taken in the given facts and circumstances. This is the only thing. Otherwise, it is a mere formality. You have already made up your mind by giving a show cause. You have decided that you are going to blacklist him. What is the point in giving a hearing?
By the same authority.
By the same authority. What is the point in giving a hearing? Unless you decide to hear independently, without any bias. And if you find that no, the grounds are sufficiently in support of the person concerned. So you show us some authority where you say that no, once the notice is issued and he gives a reply, his interests are taken care of and there is no prejudice, that we must issue him a personal hearing along with the written submissions or written arguments which he has submitted, because it has civil consequences.
Well, the question of prejudice would still not arise because there is two avenues ahead, fact-finding forums ahead of appeal as well as of review.
Now tell me one thing.
Yes.
Any authority is required to, even an administrative authority is required to arrive at a just finding. Is that responsibility met by the authority by saying that if you are agreed, go in appeal? That authority is duty bound under law to give a just finding. To say that there is a post-decisional hearing may mean in certain cases that you already made up your mind to pass this order. If you have to say anything, go before the higher authority. This is the case of blacklist. Because of the order of blacklisting, the petitioner is unable to participate in it. It is not just one contract.
Manoj, he has already submitted his tenders in several matters before being blacklisted. So those tenders are not under scrutiny. Those contracts which are pending are not being affected.
Exactly, because he's the blacklisted tenderer now.
No, they are not affected.
They're not affected.
They are not affected.
No, I cannot submit tender in any court person,
Already
anywhere.
submitted. Before the order of blacklisting.
What else?
Holiday list.
My instruction is that before the order
Before
blacklisting
order,
was
then
passed, several tenders came up, get submitted. Some ongoing works are there. He is continuing.
We are not discussing the situation before the order is passed.
Yes. Now,
the situation after.
It's a civil debt, my lord. Supreme Court says, my lord, this is a civil debt. My lord. Long-lasting civil consequence.
I can only uphold the reasons held in the show cause notice, which he has given a detailed reply. If that were not considered, my lord will take a call on this, whether the reply has been considered and reflected in the order of the blacklisting as well.
Right. You have submitted some written argument.
No, my lord, no.
I just
I'm only relying on my affidavit in opposition.
Who has submitted this?
I have submitted, my lord. Whatever I have argued, only that I have.
All right.
Heard,
reserved.
My lord, this matter was taken up earlier also. This matter relates to my lord, appointment of arbitrator. And the only ground under which the railways are opposing, my lord, is that 20% clause, my lord. The claims has to be below 20%. Lordship on the other date indicated that there was a previous decision of my lord, and it was lenient enough to allow me some time to collect the order, my lord. Two orders are there. One is, I think, will be more of assistance, my lord.
This is one WPC 1076.
1076, and it was subsequently, my lord, followed and adopted by your lordship in arbitration petition 25 of 2024.
So you show it to the respondent. You have seen it.
Read petition.
Read petition.
Only after the arbitrator had passed the award lordship, it was challenged in that read petition.
But the finding was that it is open to the
Was also observed in that the ATW's judgment was subsequently. So retrospective effect is not there. But here,
no, here the question is whether it is 20% or more. In view of the judgment which has been passed earlier by this court, it is left to the arbitrator to decide. If the arbitrator wants to decide, you have a right to go and appeal or take adequate remedy wherever you want.
In the
unless you say that no, subsequent to or these judgments are contrary to some other judgments of a higher authority. Have you gone to the judgment?
Yes.
So if you can tell me that no, this is contrary to some higher authority, counter judgments are there, that calls for a reason to look into it.
Whether it was challenged, that instruction is not with.
No, not whether this judgment, whether the proposition which has been held in this is contrary to any other authority. There are two views on this. One is that referral court is only to look into the validity of the argument, agreement. Now, while doing so, if the clause says 20%, less than 20% only arbitration, then there has to be some finding whether it is less than 20% and therefore arbitration.
We have stated that paragraph 11 that
it is more than 20%.
They have not given the claim. Please, they have not given. That is whether it is itemized claim amount, they have not submitted. That is what why we are unable to go for arbitration.
What
It's
is
not-
there, what is there in their list? Is there notice?
Not given the claim.
Notice,
What has happened here, my lord?
where is your notice?
My lord, page 130, my lord.
113.
That is also we have stated in our affidavit.
Wrong quotation of section is.
Yes, Lord.
two.
It's take 21.
Yes, 21 of the Arbitration Act.
For
How is it wrong? How is it
11,
wrong?
131,
Yeah, 130, my lord. The notice starts from page
113.
130, my lord.
13.
Annexure 15, my lord.
Yes.
Please, page 142 of the affidavit. That is what we are mentioning about. And it's page 142 of my 5922 later. Here we have specifically stated them to submit itemized claim amount.
Yes. We are bound by the judgments rendered by the bench. Minimal intervention.
Lordship, but clause 64(1) to that, as per the contract clause, Lordship, they have to submit Lordship claim, itemized claim amount, Lordship.
Before the arbitrator, my lord. It is before the arbitrator.
Where is that clause?
My lord, page
65.
my lord, page 65.
The demand for arbitration shall specify the matters which are in question or subject of the dispute or difference, and also the amount of claim item-wise. On this such dispute or differences in respect of which the demand has been made together with counterclaim or set off given by the railway shall be referred to arbitration, and other matters shall not be included in the reference.
My lord, the same argument applies for them also. They have also not raised their counterclaim.
They may not raise. You are the one who's pressing for
My lord, what has happened? Our claims will be compensatory claims, my lord. The main crux of the dispute is the illegal termination, and since there is an arbitration clause, the courts are now forbidden from dealing with their dispute. That is the difficulty, my lord. And my lord, a reference in my respectful submission can be expanded during the course of arbitration also.
That is all right, but the basis of arbitration is the contract.
Lord,
The contract has certain conditions. Now you have to raise the claim. Let us say, supposing you raise a claim, they agree to your claim. There's no need for an arbitration.
my lord, that, my lord, we have in our, if your lordship peruses our section 21 notice, our basic dispute was that illegal termination and forfeiture attempt to, my lord, withhold the security deposit. We are protected by an order of section 9, my lord, passed by the Honorable District Judge, my lord. And this is a stage, this reference was made at a stage when the, my lord, final measurement was not even done, my lord. In one breath, they are saying that give us the quantified claims, whereas they are fully conscious that they have not done the final measurement. These things can be, my lord, decided by the arbitrator, my lord.
Okay, yes.
Lordship, we have by 15/12, 15/9/22, we have already intimated them that you submit this, then we'll refer to the arbitrator, but that was not done, that is why.
We'll refer it to arbitration.
But
If you
at
have,
least they have to give the as a contract.
they will submit before the arbitrator, whatever they have.
Had they submitted it till that it may have been this dispute has been.
Because their claim is the termination.
Lordship,
So
that is
termination,
but that is a contract clause is in the
clause is with regard to item wise.
Right.
Item wise will be in respect of the work which is required to be executed by them as per the contract. Now let us say there is a, you are claiming there is a dispute arising in respect of payments to be made for particular works done or not done.
In that case, there should be some limited grounds for them before the arbitrator. In that case,
That will be item wise. But if they're putting a challenge to the entire dispute, I mean the termination itself, how can you measure it in item wise? They're challenging the, you're questioning the termination. Questioning the termination.
in that case, they have only that ground before the arbitrator. That
We don't know what ground. That is for the arbitrator to decide.
because they have
We cannot limit the ground.
their claim, Lordship. So
Heard, Mr. Represented. The application is filed for appointment of an arbitrator in the section 11. The petitioner was awarded the contract number so and dated so and so for such and such work, page number. Agreement pursuant to the contract was executed on 27/9/2018. So subsequently, the contract to terminated by which order? Termination. Termination by which order?
My lord. My lord, 12/4/2022.
Page number?
Page 120. Just a second.
120.
No, my lord, it is in page 118, my lord, 118, except 13.
118.
My lord, your participant, member partner, individual partnership hereby debarred from participation. 118 and 119, my lord.
By notice dated 31/3/2022, whereby the contract stood rescinded in terms of clause 62 of the general conditions of contract. petitioner represented before the authority and also filed an application under section 21. Also served a notice under section 21 calling upon the respondents to appoint an arbitrator. The respondents replied to the notice asking the petitioner to quantify the amounts to requiring the petitioner to submit item-wise claim amount for due reference, for consideration of reference to the arbitration tribunal. So, since the respondents did not refer the matter to arbitration, the present application under section 11 has been filed. Where counsel have been heard, readings available on record have been perused, the respondents have filed their objection opposing the claim made by the petitioners. The primary objection raised is that the in term as required under the terms of the contract, the petitioners did not raise any item-wise claim in respect of the disputes which the petitioner claims have arisen and which requires to be referred for arbitration. So, respondents submit that in the absence of any item-wise claims submitted, there is no question of conferring in the prayer or reference to arbitration. So, having considered the submissions made by the counsel for the party, and also upon consideration of the judgment referred to before this court, it is seen that this court, it is seen that coordinate bench of this court in arbitration petition number 20 of 2021 passed in so and so by order dated so and so in a similar matter arrived at a finding that the referral court under section 11 of the Act should have minimal intervention at the stage of appointment of an arbitrator. So all questions can be raised before the arbitrator appointed or be decided. And the parties, if they agree, will have recourse to an appeal under section 34. So this judgment was also referred to and relied upon in a subsequent judgment by this court, rendered in WPC 1076 of 2024 by order dated so and so. Similar issue was decided where the question of whether the where similar questions were answered, although while deciding an application challenging such a decision rendered by the arbitral tribunal. So, the law in this respect is settled by Apex Court judgment, rendered in SBI General Insurance, reported in that the referral court is required to primarily examine whether an arbitration agreement exists. If so, And if it is found that the parties have agreed to refer the matter to arbitration, cases of any disputes which have arisen, the referral court is required to refer the matter to an arbitrator, as may have been suggested by the petition, or as may be appointed by the court. Stop. Under such circumstances, this court is inclined to allow the petition and refer the matter to arbitration to decide and arbitrate on the disputes and differences arising out of the contract agreement number so and so, dated so and so, executed by and between the parties, and which to terminated with effect from so and so date. So this court considers it appropriate to any arbitral object. Two, three, H.L. Sharma, retired former judge, Honorable Justice H.L. Sharma. It's a Mr. Justice H.L. Sharma, former judge, to be the arbitrator, appointed by the court, decide the disputes arising by and between the parties. The learned prospective arbitrator will furnish a written declaration under section 12.5 of the Arbitration and Conciliation Act, and the appointment thereafter, upon the same being furnished before the court, the appointment made today shall be confirmed. Yes. We will
So
bring.
it will be listed again, Lordship?
Yes.
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 Sometime,
The registry is directed to communicate a copy of the order to Mr. Justice H.H. Sharma, former judge, the Guwahati High Court. Stop. The parties will also appear before the prospective arbitrator within 3 weeks from today, along with a copy of the order passed today. Stop. Let the matter be listed again on June 2nd of June. 2nd of June, on which date the order of confirmation will be passed by the court. List according. Deeply okay. Any instruction?
PT Lordship, we have no rule. Number one has the rule Lordship. Even as per Milo's directions, they have appeared the mediation also in the 3 times Lordship. And Lordship notice was also issued on, after mediation, Lordship has issued notice on 16/8/24. And as per reports, Lordship, they have received the notice. Lordship decide whether it's ex parte or no, otherwise, Lordship, I have no rules. They have appeared before the mediation, but now they are still here. Mediation was held, the sittings was there.
Heard A. Chaudhary, Learned Counsel. Petitioner, Mr. K. Gugoi, Learned CTC,
Not two laws.
appears on behalf of respondent number 2. None represent respondent number 1.
Lost.
This is a petition under section 11 or 6 for appointment of an arbitrator. The petitioner was awarded a contract for construction of so-and-so work, page number 16. Where is the award?
Award is annexure 2, Your Lordship.
Page number 16.
Page number.
Page 16 by letter dated 6/3/2020. Stop. Then
agreement was
executed pursuant to the
1/6/2020
award of contract on
1/6/2020.
Where do you find it?
Annexure 3, Your Lordship.
On 1/6/2020.
2020, Annexure 3, page 18. Your Lordship.
Annexure 3, page 18, we have the contract, but there's no date.
No, this is the I have here annex only the conditions of contract.
Where is the agreement?
This is the agreement. Is the part of the agreement, Your Lordship.
Have you mentioned the date in your anywhere?
Yes, paragraph 2, page 3, Your Lordship.
The agreement was executed on 1/6/2020. So, then what happened?
After that, they have completed the work, Your Lordship. However, they have asked to do some additional work. Against that work, they have not even approved, and accordingly, notice was issued, Your Lordship, on 6/12/2023.
Where is that notice?
Notice is at page 66, annexure 4, Your Lordship.
Pursuant to that, certain disputes arose. You completed the work.
Yes, Lordship.
Bills were cleared.
Not yet, Lordship.
Pursuant to the execution of the contract, the petitioner completed his work. However, the bills raised by the petitioner were not payable, have not been released. Accordingly, certain disputes arose between the parties, and
some portion of amount has been paid.
Although some portion of the amount raised have been released, but substantial amount is yet to be released by the respondents. So, where is your notice?
Notice is at page 66, Your Lordship. Annexure 4.
Petitioner submitted a notice dated 6/12/2023 laying out the claim for an amount of rupees 3,15,42,927 plus interest. So, then what happened?
Then they have replied that notice and asked for discussion, and discussion was failed, and accordingly filed this application.
The respondent authorities by communication dated 18/12/2023 intimated the petitioner that a discussion or a mediation process be initiated, and the matter was fixed on 19/12/2023. Stop. The petitioner appeared for the discussion. However, the discussions failed, and pursuant thereto, the petitioner has approached this court. Stop. There are notices in the matter was issued as per by 12/6/2024.
Yeah.
And
So my lord, that just the mediation as per the arbitration clause, Lord, and that was done, Lord.
Hmm?
As per 12/6/2024, my lord's order, Lord, which was passed as per the Lord, arbitration clause, where there is a provision is there, pre-litigation stage is there, pre-litigation mediation. Accordingly, that was done, Lord.
it is also submitted by the respondent that pursuant to direction issued by the court, pre-litigation, mediation was also resorted to. However,
Where there, respondent one is appeared,
and where the between respondent one and the petitioner,
one in the petitioner, Lord.
one and the petitioner, the same, however, did not materialize. The same, however, did not resolve the disputes. There, office note reflects that notice has been duly served on respondent number one. However, none has represented. So it is submitted at the bar that the respondent one has participated in the mediation vote, which is pursuant to the direction of this court. So under such circumstances, and we will now have to proceed ex parte against the respondent number one. So accordingly, considering the submissions made and the pleadings available before this court, the the court considers it appropriate to appoint an arbitrator to decide the disputes and differences before this court between the parties. So the court therefore considers it appropriate to appoint Sri Sushil Kumar Sharma, former district judge, district and session judge.
Let me indicate one thing, Lord, in respect to rest number two, Lord, we have no role in the present dispute between the parties.
To act as an arbitrator before this court, and to act as an arbitrator and decide and arbitrate on the differences between parties. Mr. K. Gogoi London CGC for the respondent submits that he represents the respondent number two, who has no role in the present dispute between the petitioner one, petitioner and the respondent number one. Let a copy of this order be placed by the parties, by the petitioner before the prospective arbitrator within 2 weeks from today, and the appointment will be confirmed upon receipt of a written declaration by the prospective arbitrator under section 12.5. List again on 21st May. 3 weeks, we don't do
3 weeks blocked it maybe.
huh? 2 weeks. 2 weeks. 2 weeks, good enough, you want more?
3 weeks blocked.
3 weeks, okay. Then let it be in June, 2nd of June. 2nd of June.
Highly appreciate. My lord, the petitioner in this present case, my lord, his father expired on 23/10/2011. He was working as a chokidar. Then the petitioner applied within the period prescribed, that is on 28th of December 2011. And thereafter, my lord, the DLC recommended the name of the petitioner on 2nd of February 2022. And on the ground that the vacancies, the vacant post available, but the SLC rejected it on 16/8/2022 on the ground that at the time of submission he was less than 80, he was 18 years, less than 18 years. So against agreed by the order of the SLC, we have approached the this honorable court, my lord. They as on date they have not filed any counter to my writ petition, my lord. But I am relying upon a judgment of the apex court, my lord, which had at the time of moving the matter had also mentioned, my lord, that is a 2006 9 SCC page 195. Right, Khadim Hussain versus State of Bihar.
But subsequent there to a lot of other judgments have come.
The judgment which they are relying upon, my lord, NC Santosh, my lord.
Not only NC Santosh, my lord, we are relying on, my lord, Deborah Tiwari.
The Topon Soikia case, my lord, which they just mentioned, the facts are a bit different, my lord.
When did your father expire?
2011.
And when did you apply?
2011 itself.
When was it considered? Was it considered?
DLC considered on 22.
22.
22.
SLC did not consider.
And SLC rejected on 16/8/22. DLC considered.
SLC considered and rejected. Considered doesn't mean that he has to be accepted, my lord.
No. We know that.
No, my lord, I'm just rebutting his.
One can
We
say, my
know
lord,
that.
both are saying together.
We are asking you DLC considered.
Yeah, the DLC recommended my name, my lord.
Recommended. Then SLC
Rejected, my lord.
Considered but did not accept the recommended.
Yes, my lord.
In 22.
22. The writ petition was filed in 23.
You are challenging that recommendation.
The SLC recommended.
But subsequent to that, please, office memorandum is coming.
The office memorandum, my lord, the order which the coordinate bench has passed, my lord, that is Abdul Qadir Bakshi.
But those cases were not considered. This case was considered. That is the difference.
In that case, my lord, and after relying upon this judgment, my lord, order, my lord, the Sumitra Fukon's order was passed. In that case, my learned friend had appeared. In that case, my lord, without going into the, my lord, may kindly peruse para 9.
The one thing let us understand it. Subject to correction in these matters.
The OM was under challenge.
OM was under challenge.
But our case is prior to the OM, my lord. OM is of 24. This case is filed in 23.
Now, my lord, as of today, we do not have a SLC. Unless the OM is challenged, my lord, that will become a hard deal, my lord.
Because OM is subsequent to the filing of the case. Case was filed in 23. And on this basis, my lord, the Sumitra Fukon's order was passed. My learned friend has appeared. And he has willingly agreed at page order dated 30th of April 2025, my lord. And that case also, Sumitra Fukon's case is also of the year 23, where the challenge cannot be made. Challenge is of 24.
If you look into Sumitra Fukon, come to paragraph 2. Last line.
Yes, my lord.
It was considered by DLC but not considered by SLC.
Ours also was considered by the DLC, was not considered by SLC in our case.
You are rejected by the SLC.
Rejected, my lord.
Same thing, were not considered and.
No, no, not, you can't give such a restricted meaning to the word consider. Consider means it has to be considered. Whether they give you an order or not is a different issue. So here is a case, it was not considered.
That is what, man. That is the difference.
Not considered means it has been not accepted by the SLC.
No,
No, no, no. It was not considered. We don't know what it means. You can go through the pleadings of the particular case if you want, but it says it was not considered. Here is a case where at both levels it was considered. One had recommended, other has rejected. Therefore, you are now challenging the order of the SLC. You are challenging the order of SLC.
SLC, man.
That is, so my lord, this order has to be set aside on reasoned order, my lord.
Because
on the ground.
Even if we direct the authorities to consider in terms of this Sumitra Upon and the Abdul Kadir, we'll have to pass some order on the order of the SLC. So effectively, we'll have to set aside that order. On what ground? We'll have to give us some ground.
The NC Santosh judgment which has been cited by him, my lord, it says at the time when the application is considered, my lord. And when the application was considered, I was a major, my lord.
No, my lord. Not that. The day of consideration, my lord, what is in force. So, my lord, the OM which is in force, my lord, we do not have any scheme that a minor can apply. That is Tapan Saikia, my lord, has, my lord, upheld. That there is no space.
Why was it rejected? Why did you SLC?
Page 45. Serial 15. Right hand side, my lord.
Age at the time of application was less than 18 years.
He was a minor.
So Topon Sokia's case and my case is different on the ground that Topon Sokia had applied when he became a major. He waited for 7 years. His father died in the year, his mother died in the year 2000 and he applied in 2007. Whereas I had applied within time, my lord. And in Topon Sokia's case itself, my lord, may kindly peruse the last page, my lord. There is no doubt or dispute about the fact that there is no government circular in the state of Assam permitting a minor to submit belated applications seeking appointments on compassionate ground upon attaining majority. Rather, the standing government circulars at the relevant point of time had laid down that such applications should be filed in time-bound manner and considered as expeditiously as possible. Our case, the petitioner has applied in a time-bound manner within the stipulated period as laid down in Otut Ranjan Das.
What is that office memorandum which was in force?
That my lord, once
At that point of time, he was 11. The very first thing is that, my lord, to apply, my lord, he has to be a major. He was not a major. On this ground only it is rejected.
No, that must be a part of the, that must be somewhere, I mean, in the scheme that minors' applications are not accepted.
No, my lord. It is there, he has to be a major, my lord. So, my lord, there is no scheme that a minor can apply.
No, in Santosh case, there was a time-bound period that if you are a minor, you have to apply within 1 year or something like that. Where is that? Where is the minutes? I'm not sorry. The OM which was governing.
OM I have not any, my lord, in this.
You get.
I'll file an additional affidavit and bring it on record.
Bring it.
Yes, my lord.
Matter stands deferred as the counsel to the petitioner is chief to file an additional affidavit which being on record. The office memorandum, which was in force at the time, the SLC had considered the case and rejected the petitioner's claim. He prays for
2 weeks time.
2 weeks time. It's after 2 weeks. Mr. R for PWT, MSM, Charji for SLC. 1, 2, 6, and 7. হয়তো সেইটো সেইটো বেলেগ অকল ইয়াৰ লগত নহয় এক্সপেক্টেড ইয়াৰ ভিতৰত এটা বাদ বনাই থৈ
Last occasion, the lordship was directed the other side to take instruction.
You are the first wife, second wife.
I am the daughter of the deceased employee, and daughter and son before this honorable court. My mother expired already in 2019.
You
After the demise
daughter
of
and
my
son
mother,
or of the first wife.
yes. After the demise of our mother, my father married to respondent number 5.
And respondent 5 is nominated in the PTO, in the
yes.
pension.
Yes.
You are not, your names are not there.
Yeah, our names are also there. So there is no dispute in regarding respondent number 5 and petitioners. Our father expired in 2021.
Right.
In lordship, for a moment, if your lordship peruse page number 32 and extra 12. This is a departmental communication lordship. In the last paragraph, the hearing was conducted, but there is no dispute between us. So our file was sent for sanctioning of the family pension and retirement benefit, but till that we have not received anything. The last paragraph, in this connection, one official hearing was held with the aforesaid family members of that Moon Talukdar, and they eventually consented to accept all the benefits in equal parts. We have no any dispute.
But this has not been implemented.
Yes.
That is your agreement.
Yes. Till that we have not received. And regarding service of notice upon respond number 5, it is already completed. In the last week of April 2025, matter was placed before Lodge.
Mr. Botakur, learned counsel for the petitioner. None represents the respondent. Anyone for excise here? None represents the respondents. So, notice it, the petitioner, petitioners and private respondent number 5. Petitioners are the children of late
Moon Talukdar.
Moon Talukdar, who was an employee at the excise department government of Assam. So the private respondent number 5 is the second wife of late Moon Talukdar. Stop. Late Talukdar expired on 19/3/2021. Stop. The first wife of late Talukdar, namely the mother of the present petitioners, also expired on 15/9/2019. And after her demise, late Moon Talukdar got married to the private respondent number 5. Stop. It is submitted by the petitioner that no child was born out of the wedlock between of Moon Talukdar and respondent number 5. So, pursuant to the demise of late Moon Talukdar, the petitioners and private respondent number 5 approached the authority with all necessary documents, and the parties agreed to accept the service benefits of late Moon Talukdar in all equal parts. Stop. This decision of the petitioners and the private respondent number 5 is reflected in the communication dated 30 May 2024 issued by Superintendent of Excise Corbetta. By this communication, the fact that the petitioners and the private respondent number 5 had agreed to share the service benefits in equal parts was communicated to the Commissioner of Excise Assam. Stop. So this is only for GIS.
Lordship, there are 4 annexures, 12, 13, 14, and 15.
Okay. There are 4 separate communications addressed by the Superintendent of Corbetta. One in respect of group insurance scheme, GIS, one in respect of the NPS deposit balance, one in respect of the earned leave encashment deposits, and one in respect of what is this page number 35 for? Regular salary.
This is Lordship, the last salary drawn by the deceased person. That may be
The one in
allowed to
respect
draw.
of payment of regular salary as per new provisions. Stop. Since these claims were not settled, the petitioner number 1 filed a representation before the Deputy Superintendent of Excise on 30/12/2024. However, no response was forthcoming from the respondents. Being agreed, the petitioner is before this court. Stop. On on 19/3/2025, this court had issued notice, and the counsel representing the excise department was permitted to complete the instructions. So similar order was passed on 30/4/2025, enabling the standing counsel to complete his instructions. So today, when the matter is called up, none represents the excise department. So since the notices were issued and counsels have represented the respondents, and upon taking into consideration the submissions made by the counsel to the petitioner, this court is inclined to dispose of the writ petition. At this stage, however, considering the fact that the claims made by the petitioner and the private respondent are in respect of the service benefits, service and other retirement benefits of the petition of the late Moon Talukdar, who is an employee of the excise department. This court is of the considered view that the matter be listed again on 16th of May, enabling the respondents to apprise this court about their instructions, if any. Since the standing counsel is not available before this court, copy of this order be marked to the office of the Senior Government Advocate, Assam, for onward communication. It is made clear that if none represents the excise department on the next day, the matter will be disposed of. We are giving one more date, just in case the department wants to give any instruction. Fixed on 16th. 16th of May. To last line of the law order be brought with a notice of registrar division. Yeah.
Lordship, the petitioner counsel as well requested me to take adjournment of the matter, Lordship. He has due to some personal problem.
Matter stands deferred to be listed next week.
Okay.
Next week,
Lordship.
on a request made on behalf of the council for the petition, MSR Devi appears for the learned CGC appears for the respondent. Yes.
I was pleased to appoint an arbitrator in this matter, retired district judge, Your Lordship. The disclosure has come in one of the matters, but the difficulty is that he's based in Bongaigaon, my lord. So we would request if somebody who's based in Guwahati, my lord, can be appointed.
And you have to file an application.
I understand, my lord, but this is actually the disclosure came yesterday, my lord. Based on oral request, my lord.
He's not based in Guwahati.
No, he's not based in Guwahati. The disclosure, in fact, has come. I can share a copy, my lord. As it is, it's not a very high stake matter. The conveyance plus stay, all these expenses.
You file an application requesting for a change.
But because the appointment is not final as per your last lordship.
That's right, but your application will have to be recorded. We'd like to have it on record.
I will do so. I'll file an application.
File a short application giving the reasons as to why you want the change.
My lord. Because I was not at all aware that he's based there. Because last time we've seen the.
No, but this order was required to be communicated to him.
Yes, we've communicated.
So,
in response to that, he's.
Ordinarily, it is expected that you will go and appear before the prospective arbitrator communicating that you are appointed as an arbitrator.
We sent an email to him and he responded via email.
That's the whole problem. You file an application.
I'll do so.
Counsel for the petitioner. We file an application seeking alternative arbitrator to be appointed. I submitted that the learned prospective arbitrator is the Pradeep Kumar Das.
Yes.
That former district judge. He is based in Bongaigaon and it is likely to cause some difficulty to travel from Guwahati to Bongaigaon on every day. The council is permitted to file the application. I will represent the respondent. Which after
Item 58, my lord.
no, you first tell me the date, how much time you want.
No, I'll file it within a week, my lord. I'll file it. 13th, could it be? 13th of May.
13th, I take a miscellaneous day, 14th, 15th.
14th, I have some difficulty, my lord. It could be
19th.
Permit me to join through VC in that case. Any date, then I'll.
Yes, 16th. Will it be on 16th?
Yes. Just one more aspect I would like.
Out your dates and inform the court markers.
19th. Well, just one aspect I would like to draw your attention.
No, this is now first tell us it is 16th or 19th?
19th.
19th.
You want 19th? 19th
Yes.
is fine. I'll join through.
Yes, then?
Well, there's two aspects. There's two matters. One, Abhinash Boru and one Jitendra Tamuli. Jitendra Tamuli is listed as
Item number?
Item number 56, Your Lordship.
Yes.
So there was slight error in the order, my lord. Here, the post was that of DEDC. The post that is mentioned in the order is DEDC. Actually, my lord, it is DEDE.
Okay. Here also you want to change?
Yes.
You point out on the next.
In the
correct it.
application, same application.
We'll correct it.
My lord, in item 58, my lord, I think it's then separated, my lord, because the petitioner has died long back.
Is it?
Yes, Purin Bora, Purin Bora.
I mean, that's correct, Milord, and I've received no instructions. I've communicated to them that we will have to move
We'll
it.
close it. It is submitted in item number.
Since the other matters are being deferred, if she's a widow, I mean, then she also went through some trauma in the sense she suffered an accident. So if she comes back well and good, with otherwise, of
Alright.
course, it will suffer its fate.
Let all these matters be listed on 19th.
Obliged.
Wait, please, your lordship, my lord, that we are challenging in this selection process. Records were called for, my lord, records aisa nahi. The DC's office, my lord, the records are in DC's office.
No, my, it cannot be this is office, my lord. It is, the order was passed by the, my lord, commissioner
Division.
of the division, my lord. So,
After the disposal, April records have been sent back, to my knowledge. That I'll argue in detail, my lord. That premier officer doesn't like because review is not the alternative remedy. They decided. One of the decision he has shown, my lord, their decision is not applicable in the light of the fact that.
So you are not selected.
Yes.
You are not selected. There is a provision for review, I think.
The review is not alternative. I filed appeal. After appeal, I have come here.
What happened in the appeal? Dismissed.
Appeal, these 2 days. My lord, very short, critical order. And this is also not an order of appellate tribunal.
So what are your grounds?
My lord?
Tell it.
My lord?
What are your grounds for tell it?
Challenge, my lord, the selection was not proper, my lord, and the appointment given to the respondent, private respondent was illegal. And therefore, records, your lordship wanted to see the records.
What do you want to point out from the record?
No, your lordship were called because your lordship wanted to examine the records of selection. You let them produce the records, my lord, on a date fixed by your lordships.
Yes, Mr. Dhor.
my lord, again, I will write, I will try to bring the record.
Who are you representing? You have responded to the petition.
Yes.
You have filed your affidavit.
Yes, file, my lord.
Regarding the mandate, there is an executive committee available to certify an executive comment.
Appeal is filed.
Yes, appeal is filed.
Appeal filed.
That is review, my lord. Review. Your lordship knows the limitations in review. Review is not alternative remedy, my lord.
My lord will take up the matter as a whole.
Yes. Because here, my lord, 162 A deals with removal from service. B, appeal. There is the first appeal to the district commissioner, my lord. Then second appeal lies to 162C. Now it is instead of my lord, commissioner of division, now it is the director of land records.
We'll see. You get your record. Mr. R.P. Mr. Hardcore, Council for Home. 4. Who is 4 and 5? Whiskey and whiskey and Mr. S. Dotto 4, respondent 1. And Mr. S. Kapati for SK. S and Kapati for respondent number 6. The respondent 6 is the selected candidate, and they have disputed the content of the document by finding their ability. The other respondents have not filed. Council, in terms of the earlier order dated 15/12/2024, the relevant records pertaining to the election date was called for by the court. That the Mr. Hall does not have the record available. He prays for 2 weeks' time to complete the instructions and procure the necessary report. List after 2 weeks.
Yes. On a date.
Have it on 27?
Right. 27 May.
27 May.
Please, Your Honor. The government has filed an affidavit. Will I could file and reply?
We give an order distributed here. If we pass an order, the counsel for the petitioner seeks liberty of the court, leave of the court, file affidavit. The affidavit in opposition filed by the respondent. Prays for 3 weeks' time. List after 3 weeks.
Hello.
Yes.
My lord, I was appointed as CRPF personnel after interview, and lordship may kindly see my appointment letter. That is,
pleading is complete.
Yes, pleading is complete. They have also filed affidavit. My lord, very page 22, kindly see page 22. Yes.
Yes.
Offer of appointment for the post of Constable General Duty in CRPF. As a result of successfully qualifying, written examination conducted by the Staff Selection Commission and completion of recruitment process, you have been allotted for enlistment in CRPF. Accordingly, you are provisionally selected for appointment as Constable General Duty in CRPF. The post is purely temporary but likely to continue. It is addressed in the top, kindly see top left side, to Subroto Sarkar, roll number so and so, son of Uday Sarkar, so and so. This is my appointment letter. Thereafter, Lordship would see page 26. Page 26, operative portion may be seen, bottom, page 26 bottom. The above patient brought to, above patient means I, Subroto Sarkar, of Composite Hospital, CRPF, Guwahati on 2/6/17 in state acute psychosis in a form of irrelevant talking for 3-4 days, fearfulness, not obeying commands, or so and so, so many things were brought. Then recommendation to board, as patient is a case of acute psychosis due to stress and very prone for further relapse in the phase of stress, he is not fit for further combatized service. So that was the order. And thereafter my appointment was cancelled. That is page 27. Page 27, para 3 may be seen. In view of above, your candidature for the post of constable is hereby cancelled. You are found unfit for combatist service, and you are also directed to leave this location with immediate effect. So this order was passed on 15/9/17, and I was appointed on 11/5/17. That means more than 4 months I served. In such a situation, my lord, there are also reports in my favor. Not only this, in my favor report is there. That may be seen page 25. Summary of medical examination. Lastly, it is said that fit, absent, present, fit. So here is no unfit words. But later on, the medical board found me unfit for combatant duty, and so my service was terminated. Then I approached the Honorable High Court. High Court's order, page 31.
Yes.
Operative portion may be seen page 33 bottom. This order is passed not taking note of any requirement of procedure to be followed by CRPF, but on a humanitarian consideration to evaluate once again as to whether the petitioner is actually suffering from such disease. This petition stands disposed of as indicated above. Thereafter, my lord, the matter order of the Honorable High Court was communicated to the authorities, and authorities passed order, that is page 35. Operative portion may be seen page 36. Para 7, 36. On going through clinical psychologistics report dated 25/1/23 submitted by Dhoritri Datta, lecturer, clinical psychology department of Physiatry, GMC Guwahati, Board of Officers of CRPF Guwahati, reassembled on 10/2/23, opined that roll number so-and-so, Sri Subroto Sarkar, is an old case of acute psychosis, stress induced. And lastly, my lord, the order is page 36(8), para 8. As the Medical Board of CRPF Guwahati has declared Subroto Sarkar unfit for combatant role in armed forces, hence his case for appointment to the post of CTGD 02015 in CAPFS cannot be considered and is rejected on medical ground. So we have partially challenged this order in another manner, because there are various orders of the Honorable Supreme Court that if a person is found unfit for combatant duties or heavy duties, armed duties, due to his mental stress or any other thing, there are so many other ministerial posts in CRPF department. So we have filed this writ petition only for that ground. Kindly, Your Lordship may also see the earlier orders of the Honorable Court. That was, they were asked to consider, to see whether that is there or not. In this regard, my lords, I have several judgments of the Honorable Supreme Court. One is Narendra Kumar's case. Another is my lord Periyasamy. Let's see. I am Narendra Kumar's Chandla's case I am taking first. Kindly see para 2. The appellant, while working as substation attendant in the pay scale of so-and-so, unfortunately had to be operated on February 13, 1984 for so-and-so, and ever since he was treated in Tata Memorial Hospital, Bombay, up to March 18, 1985, and thereafter he was discharged and his right arm was completely amputated due to the said sarcoma. It is a cancer effect, but it was arrested. The doctor in his letter dated so-and-so recommended that he can assume his normal duties. The bone of his right arm is completely missing. He shall to work properly. So this there are description. And lastly, finding of the honorable court that Lordship may kindly see para 7. Article 21 protects the right to livelihood as an integral facet of right to life. When an employee is afflicted with unfortunate disease due to which, when he is unable to perform the duties of the post he was holding, the employer must make every endeavor to adjust him in a post in which the employee would be suitable to discharge the duties. Asking the applicant to discharge the duties as a career attendant is unjust. Since he is a matriculate, he is eligible for the post of LDC. For LDC, apart from matriculation, passing in typing test either in Hindi or English at the speed of 15/30 words per minute is necessary. For a clerk, typing generally is not a must in view of the facts and circumstances of the case. We direct the respondent board to relax his passing of typing test and to appoint him as an LDC. Admittedly, on the date when he had unfortunate operation, he was drawing the salary in the pay scale of so and so. Necessarily, therefore, his last drawn pay has to be protected. So this is one case. Ratio of this case is
No,
applicable.
these are matters where the person concerned is not a member of a discipline force. Here you are a member of a discipline force.
No.
Now
I
you
am
have to
not for
point
that.
out that there
I
are
am
provisions to show that even in a discipline force there are avenues where a person can be employed, need not be employed in a combatized
yes.
role. That is, I think there are judgments of this court.
No, my lord, my submission is that I am that is rifle duty. I am not on that.
No, I'm not
There
on
are
that.
clerical duty.
I'm not on that, Mr. Mahmood. It's not like that. Some of the, this is what CRPF.
Yes.
In some of the forces, all the employees are required to go for basic training.
Yes.
Even if they are not in a combatized role, they will have to go for basic training.
I am higher secondary passed.
Not high, not academic. Basic training as is necessary for.
That would be provided by the authority even after appointment.
That's right. Whether
That-
he is competent to undergo that training. Firstly, you have to tell us whether there is any necessity for, is there an exception under the rules, CGC?
No, Madam, in para 10 of our affidavit, we have stated that, my lord, in every paragraph 10 of case 50, my lord.
Yes. Page 50.
Yep.
What have you stated?
We have stated, my lord, that it is submitted since the petitioner participated in recruitment process constantly held during the year, and on finding a medically unfit by the board of medical officer, the petitioner is not appointed in the further. All the posts in the CRPF are completized, and each and every member of the CRPF, irrespective of their cadre, has to clear the basic training, which include running,
This is what I was saying. There are 10.
No, my learned friend is not fully correct. Because for appointment of LDA or UDA or ministerial
You are
job,
not getting the point.
running is not necessary.
No, you're not getting the point. It's not your choice or my choice. It is what the rules say. If the rules say that they have to undergo the basic training, even for any other jobs, then they'll have to go for the basic training.
Can you see the next judgment? A.
But that is also not in a combatized,
Can you see
not for
the
discipline.
concluding stanza is para 12. That is Peria Swami. That in these circumstances, para 12.
Mr. Mahmood,
Hello?
your endeavor is to convince the court.
Yes.
The court's endeavor is to see whether we can give you a relief. The endeavor is not to send you back disappointed. We'd like to give you a relief if possible. Therefore, this question is raised. They have already stated in their affidavit that all the posts are combative. Either you say that this is an incorrect statement, and as per rules or regulations or OM, some posts are not required to be undergone this basic training. Number two, that even if it is combatized, he is in a medically he is in a position to clear the basic training, and therefore he can be accommodated there.
My lord, I have two submissions. First thing, by affidavit, case cannot be improved. There are judgments of the Supreme Court. Secondly, my lord, if even there is no provision of law, court may provide discretionary justice to a person because he was
Not
appointed.
in a service matter, not in a appointment matter.
But civil posts are there, my lord. Civil posts are there.
That you point out what civil posts are
Yes,
there.
clerical jobs are there. Clerk, this peon, chowkidar, so many persons are there, my lord. They are not disclosing this, I don't know why. Whereas
You first show us the appointment order of your
yes, appointment order.
Petition.
Page 22.
22. Now, after the appointment order, what happened?
I did some duties for.
Did he perform in the basic training? Did
Yes.
he undergo the basic training?
Yes, that was the 4 months I worked.
Did you undergo the basic training?
Yes, that is it is also mentioned.
Where?
That successfully qualifying written examination conducted by Staff Selection Commission and completion of the recruitment process you have been allotted. The recruitment process, I think it includes everything.
No, it does not. Basic training is after you are appointed.
Yes, after my appointment, and that was done, my lord.
Where is that?
That page 23 may be seen. Page 23. There are some restrictions also. If you accept the offer of appointment on the terms and conditions mentioned above, page 23, serial number 4, you should report for duty to DIGP Group Center CRPF 9th mile, so-and-so Zorabat, Guwahati, Assam, on or before 31/5/17 with original copies of the following documents. So those processes were completed. Thereafter, medical examinations were done. That is page 24, kindly see. Government of India Ministry of Home Affairs, medical exemption report for combined recruitment constable GD number so-and-so, Subrata Sarkar. Summary details presents fit, there is no unfitness. So this is the
Why the page 26 medical report was necessary? Who referred it?
No, it is learned that after some days he started talking unnecessarily. So that created a doubt among the minds of the authorities.
You tell us whether he had completed basic training. Then we can examine this matter from that perspective.
Then next week, any day, let me take the information then. But so far, I think he was, because he did duties nearly 4 months. So without
Sir,
completing his training, how he can be allowed to work?
Mr. M. Mahmood Lalan, let the stand paper to be taken up after 1 week. After 1 week?
A date may kindly be fixed.
21?
21
22
time.
20,
Huh?
22 my lord.
22,
Either 22 or my lord.
23.
Yes, my lord. 22.
You hearing? Yes. No. What did you- You have gone through the translation. Last order says records. Oh no, sorry. Records are in Hindi. You wanted some time to translate or something like that.
Lordship, in fact, in listed office so long, I'd send back the records. If you're working in visa, then I'll collect. It's nearly 2 years.
2 years. 27?
Mal.
That will be referred to be listed on 27. By which time the learned CGC will produce the relevant reports of disciplinary proceeding. List on 27. May.
Published.
Yes. Yes, please.
My lord, item number 59, my lord.
Yes.
My lord, this matter was heard extensively by your lordship. My lord, on the last occasion, the respondent want to rely on some affidavit in opposition with relating to the authorization of the person who has signed this. My lord, we have given a reply in which we have annexed the authorization. My lord,
So I think that is already settled now.
yes, my lord. My lord,
Is
I humbly request your lordship to kindly appoint an arbitrator if my lord, if my learned friend has no objection to it. And let's all point be open before the learned arbitrator.
Yes.
Can be appointed.
All right. Heard counsel for the parties. This petition is filed by the petitioner praying for appointment of arbitrator under Section 11 of the Arbitration and Conciliation Act. In 1996, the petitioner was awarded a contract Where is that? Where are the particulars of the contract?
And at page 32 of the petition method, the NIT. And letter of acceptance is at page 154.
Have you quoted quoted this in some paragraphs? Is it mentioned in some of your paragraphs here?
Yes, yes, my lord, yes.
Paragraph 4.
My lord,
Petitioner
from paragraph
participated. Yes,
4
participated
onwards.
in a tender process invited by the respondent, and on 9th October 2015, the respondents issued the letter of acceptance in respect of the bids submitted by the petitioner for execution of or construction of new beach broad gauge line from Giribam to Imphal at a total cost of 50,33,28,786.68. Pursuant to the issuance of the letter of acceptance, the formal agreement was also executed by and between the petitioner and the respondent on 26/11/2015. The petitioner had opted for registration under Manipur Value Added Tax 2005 and had filed its return under the said act. So, subsequent to the change in the tax regime brought in by the GST with effect from 1/7/2017. The petitioner also applied for and was issued a GST, proper GST registration. So, the dispute arose between the parties with regard to the tax liability. In respect of the petition. So, is the submission of the counsel for the petitioner that because of incorrect understanding of the GST provision, a demand was made to an amount of rupees 1,87,20, 0.44 for recovery of the said amount against excess GST neutralization paid to the petitioner's bills/security deposits lying with the respondent. Despite the response of the petitioner to the purported recovery sought to be made against excess GST neutralization paid, the respondent authorities rejected the claim of the petitioner. So, it is submitted that under the provisions of the contract, there is a provision for referring the matter to arbitration in respect of any dispute or differences that may have arisen between the parties. So, it is submitted that this denial of the amounts claimed by the petitioner amounts to a dispute and a difference arising out of the contract agreement executed by and between the petitioner. Therefore, notice was served on the petitioner, on the respondent for appointment arbitrator. Stop. Where is your notice? Did you serve a notice calling upon the respondents?
Yes, my lord. Yes, my lord. My lord, section 21 notice is at page 250.
So pursuant to issuance of the notice, they demanded for waiver.
Yes, my lord. That is at page 255.
Pursuant to receipt of the notice, the respondents demanded for a waiver by the by the petitioner, so that an arbitrator from the curated panel maintained by the respondent authorities can be appointed. So the petitioner did not accede to the demands made by the respondent. and consequently no arbitrator was appointed. Being aggrieved, the present application has been filed, praying for appropriate direction or order, appointment of an arbitrator. Stop. Correct. The respondents have contested the matter by filing the objection at the relevant point in time. The objection raised was that in view of the judgment of the, what is that, CORE?
Yes, sir.
CORE
Central
judgment.
Organization of Railway Education.
What is the citation of the first judgment?
My lord, I have the Supreme Court citation 2024 INSC 857.
Sorry,
2024 INSC.
You are referring to the larger bench judgment?
My lord.
No, the earlier judgment, the matter which was referred to larger bench.
That is 2019, my lord, 16 STR 1234. 2019, my lord, 16 STR
2019 16 SCR 1234, whereby the apex court had held that in the event of an waiver, the court may the, the, the that uh, the presence the the fact that the waiver clause is available does not affect the rights of the parties otherwise. So this judgment was ultimately referred to a larger bench and came to be decided on so and so date, reported in. What is that larger bench judgment?
My lord, citation.
Yes, citation.
My lord, 2024 INSC, I am giving the Supreme Court citation, my lord. 857.
2024 INSC 857, whereby larger bench held that the waiver clause has the effect of will will the waiver clause will be hit by the waiver clause if the waiver clause uh, will affect the rights of the parties as uh, if the parties do not accept the curated panel, they must be given liberty to appoint their own arbitrator. So, subsequent thereto, the judgment has been referred to and relied on several other subsequent judgments. Under such circumstances, in view of the clear law laid down by the apex court in so and so, the respondents have accepted the law laid down by the apex court and submits that they would abide by any order passed by the court for appointment of an arbitrator. So, the other argument, other objection raised is that the notice was issued by the power of attorney holder, and therefore no notice under section 21 can be said to have been issued by the petitioner or received by the respondent to invoke the provisions under section 11 of the Act. So, this aspect of the matter has also been dealt with by coordinate judgment of a coordinate bench of this court, rendered in arbitration appeal number 29 of 2014, decided on 7/9/2017. So this judgment has also been followed by this court in Suenso versus Suenso, whereby it was held that notice under section 21 of the Arbitration Act, notice by power of attorney holder would be sufficient compliance of the rigors of section 21 of the Arbitration Act. So, in that view of the matter, the do you agree with the arbitrator named here?
They reply on it.
In their petition, page 27, paragraph 39.
Well, it would be better only if it is appointed to the panel.
Because it is from the panel only.
Mhm.
Page 27, the second name.
Will appoint that. For that again, I have to take the consent. My lord will appoint other name, other.
The no, it's from the panel only. We'll name it accordingly.
Again, I have to take consent from the.
We are appointing it. We are not asking
My
you
lord.
to agree to it. The petitioner had suggested the name of Mr. M.K. Panchaji, retired district judge, former district judge, sole arbitrator. He appointed to decide disputes arising out of this matter between the parties. In view of the fact that, in view of the settled law laid down by the apex court, as also view of the judgment of this court holding the field respect of notices issued by power of attorney holders would be sufficient compliance under section 21. This application is allowed. The Mr. M.K. Bhattacharya, former retired district judge, is appointed as the sole arbitrator to arbitrate and decide on the dispute arising by and between the parties. So, the prospective arbitrator, this appointment, however, is subject to a written declaration issued by the prospective arbitrator and placed before the court. Let the parties appear before the arbitrator on. We'll give you a appear within 3 weeks. 3 weeks. 3 weeks. And stop. The matter be lifted again on in the month of June. The 4th of June. On which date? By which date? The written declaration by the prospective arbitrator should be filed before the court. Upon receipt of such prospective, upon the written declaration furnished by the prospective arbitrator, the appointment will be confirmed. List according. How many petitions are there?
3 petitions.
Same order.
Same order.
Same
3
order.
contracts.
3 different contracts.
3 different.
Same order, contract number. You put it in a piece of paper, the contract numbers and the date.
We have given a note. I have prepared a
Yeah,
note.
you prepare
And the amount also, my lord.
and the
Amount is also okay. Apply.
I'm grateful, my lord.